All right, everybody. Day two, let's go. All right. Good morning, everyone. Welcome to the second day of the Occupational Safety and Health Administration's informal rulemaking hearing for amending medical evaluation requirements for certain respirators. My name is Katie Harrison from Eastern Research Group. I'm a contractor to OSHA. Before we begin, we'd like to go over some logistics for today's public hearing, which is being live streamed from Zoom for Government to YouTube. As a reminder, all attendees are muted automatically with microphones, webcams, and chat box disabled. All attendees can access automated closed captions by clicking on the CC icon in the control panel at the bottom of your screen. All YouTube viewers will have access to audio translation the day after the webinar. If you are viewing in Zoom, audio is available by computer speakers or by telephone. Your call-in information is available in your registration confirmation email. And to ensure allotted time is adhered to during the testimony delivery, we will display a clock timer on your screen and will start it once you begin your testimony. Once time is reached, the judge will thank you for your comment and move on to the next speaker. If you're speaking today, you will receive a notification on your screen that you're being promoted to the panelist group a few minutes before it is your time to provide testimony. Once promoted to the panelist role, you will be able to unmute yourself and turn on your camera. We ask that you do not unmute or turn on your camera until your name has been called and you have been asked to start your testimony. Speakers connected by telephone only should unmute their phones when called to testify by clicking *6 on your phone. Depending on timing, there may be opportunity to ask questions of other speakers giving testimony. If you're logged into Zoom, you can press the raise hand button in your control panel to indicate that you have a question. And if you're called in by phone only, you can press *9 to raise your hand. And the moderator will read off the last 4 digits of your phone number when it is your turn to speak. If there is time, you will be called by name and promoted to panelist group to unmute and ask your question. And if you're having any technical difficulties, please send an email with your name and phone number to meetings@erg.com, and I'll be happy to troubleshoot with you. So thank you again, and I'll now hand it over to Judge Bell to provide an opening statement and go over administrative matters.
Thank you, Katie. Let's go on the record, please. And the hearing will now come to order. Today's the final day of an informal public hearing on the Occupational Safety and Health Administration's proposed rule on amending the medical evaluation requirements in the respiratory protection standard for certain types of respirators. The notice of proposed rulemaking was published in the Federal Register on July 1, 2025, in volume 90 of the Federal Register, beginning at page 28,463. I'm Judge Bell. I'm an administrative law judge for the U.S. Department of Labor, and I'll be presiding over the hearing today. The purpose of the hearing is to receive from interested parties their oral testimony, as well as other information pertinent to the proposed rule. After this hearing and the post-hearing comment period have closed, OSHA will review the entire record in determining the content of the final rule. My role as presiding judge is limited to conducting the hearing to assure that a complete and accurate record is made and that all interested parties receive a fair hearing and have an opportunity to submit their information. The hearing schedule and OSHA's procedures governing this hearing are available on the deregulatory rulemaking page of OSHA's website. These documents were sent to people and organizations who filed a timely notice of intention to appear at this hearing. A few words about the nature of the hearing. Despite the informal nature of the hearing, it is governed by rules, both OSHA's rules governing hearings, which can be found in 29 CFR Part 1911, and the hearing procedures issued which are specific to this rulemaking. These rules are meant to assure that everyone has a fair opportunity to speak and to express an opinion about the proposed rule. To that end, they allow me to hold witnesses to their allotted times, limit undue repetition or excessive argument, and to generally keep the hearing on schedule. Any written comments you have submitted to the docket are already a part of the record of this rulemaking. In the rare case where a witness wishes to provide any other documents that have not already been entered into the docket, they should provide them by email to this address, OSHA events _ DSG@dol.gov. And that should be done before the witness begins his or her testimony so that they can be designated as exhibits in the record. Because all pre-submitted documents are already part of the record, we ask that your oral testimony concentrate on presenting the highlights of your written comments or clarifying or expanding on your written submission. Hearing participants may also submit additional testimony or evidence for a period following the end of the hearing, and will have an additional period of time after that to submit any briefs based on the record as a whole. I'll set deadlines for those two periods at the end of the hearing, and at that point, the record for this hearing will close. Today, after each speaker or panel of speakers completes giving their oral testimony, OSHA representatives will have the opportunity to speak or ask questions to that panel. When OSHA has finished asking questions, there will be an opportunity, as time permits, for persons who filed a timely notice of intention to appear to question the witness or panel. Participants may only direct questions to witnesses with whom they have no organizational affiliation. This is intended to prevent the use of the question period to extend testimony. In general, this is the process I intend to follow. After OSHA has finished asking questions of a witness or a panel, I will ask participants who wish to ask questions of the witness or that panel to identify themselves by pressing the raise hand button, which you can find at the bottom of the screen, or by pressing *9 on their telephone for those who have called in. Based on the hearing schedule and the number of participants who wish to ask questions, I will determine the order in which participants will question a particular witness or panel and any time restrictions that are going to apply to that questioning. If there are more questions than we have time for during the scheduled period for questioning, it may be possible to ask additional questions after the conclusion of the final witnesses testified today. Further, if witnesses are unable to answer a question during today's hearing or would like to expand on the answers provided, they are welcome to use the post-hearing comment period to submit such information. I'd like to remind you that the proceeding today is being recorded and it's also being transcribed by a court reporter. To ensure that the reporter is able to provide an accurate record of the testimony, please try to remember to provide verbal responses to all questions because the court reporter has a difficult time seeing if you only nod or shake your head in response. In addition, please remember to identify yourself before the beginning of your testimony or before asking or answering a question. This is a forgotten rule, and I'll do my best to try to help remind people to identify themselves before speaking or before asking or answering a question. The transcript of the hearing will be uploaded to the hearing docket on regulations.gov approximately 2 weeks following the hearing. Mr. Levinson, I'd now ask the OSHA panel to introduce themselves.
Thank you, Your Honor. I am Andrew Levinson from OSHA's Directorate of Standards and Guidance.
Dr. Jonathan Baer from OSHA's Directorate of Standards and Guidance.
Dr. Minda Nieblas from OSHA's Directorate of Technical Support and Emergency Management.
Dr. Bob Blicksilver, OSHA Standard and Guidance, Office of Regulatory Analysis.
That's the OSHA panel, Your Honor.
Okay, thanks very much. Mr. Barrett, I'd ask those from the solicitor's office who are here today to introduce themselves, please.
Of course, Your Honor. Joseph Behrens with the Office of the Solicitor, Department of Labor.
Tessa Vislin with the Office of the Solicitor.
Thank you all for being here. Unless there are any other announcements or housekeeping matters, I think it's time for us to begin with the public testimony. The expected speaking order will be displayed on the screen. Our contractor will introduce each speaker in turn and promote them to be panelists. When you are called on to testify, please state your name and affiliation for the record. Speak slowly and clearly so that our court reporter can make an accurate record. And at this point, I think we're ready to begin.
Thank you, Judge Bell. Timothy Hannigan, I have promoted you to panelist. You are welcome to unmute and turn your camera on. And as a reminder, we have a courtesy timer in the bottom right-hand corner of your screen.
Mr. Hannigan, welcome. You may begin.
Good morning, Judge Bell. Timothy Hannigan, General Counsel for the Firefighters Association of the State of New York. Mr. Levinson, members of OSHA and our partners in the Department of Labor, good morning. FASNY is the voice of New York State's 81,000 volunteer firefighters. Since 1872, we have informed, educated, and trained the volunteer fire service in our state, and we are the largest state association of volunteer firefighters in the United States. Volunteer firefighters serve all corners of New York in rural, suburban, and urban areas. And as an interesting point, we are the only state in the nation whose NFL stadium is served exclusively by volunteer firefighters. Nearly all of our members, EMS and fire, including myself, are directly affected by your respiratory protection standard, whether through self-contained breathing apparatus used in interior structural firefighting or through the loose-fitting face masks that many departments issue for wildland smoke exposure and infection control duties on medical-related calls. Accordingly, FASNY has a direct and substantial interest in this deregulatory rulemaking and appreciates the opportunity from you to offer comment. In terms of cost, our volunteer fire departments administer the respiratory protection standard with a fraction of the administrative and medical resources available to our career departments and private industry. Every firefighter who may be required to wear a respirator, whether that's an SCBA face piece for interior firefighting or a loose-fitting mask during EMS response, must first be medically evaluated by a physician or other licensed healthcare professional. For volunteer departments, particularly those in rural areas of our state, scheduling that evaluation means locating a physician who's A, available, and B, willing to complete OSHA's Appendix C questionnaire, coordinating that physical around the volunteer's outside employment, and absorbing a cost that is frequently borne by the department itself or the volunteer personally, rather by an employer with an occupational health program already in place. Because volunteer rosters turn over regularly and physicals are performed annually, this burden recurs continuously rather than as a one-time onboarding cost. FASNY supports the proposed removal of the mandatory medical evaluation requirement for filtering face piece respirators and loose-fitting powered air purifying respirators, subject to some clarification. As the proposal indicates, and as we understand it, the proposal does not reach SCBA, which remains the primary respiratory protection used in IDLH atmospheres and interior structural firefighting under paragraphs G3 and G4. FASNY's members will therefore continue to receive medical evaluations before SCBA use, preserving physician oversight where the physiological burden of respirator use is highest. The deregulatory proposal instituted by OSHA instead targets the lower burden category of filtering face piece respirators and PAPRs, which OSHA has preliminarily determined impose a materially different physiological demand than tight-fitting pressure demand SCBA face pieces. FASNY agrees. For our members, the advantage of the proposed rule is one that it could remove a recurring administrative and financial obstacle to equipping volunteer firefighters with filtering face masks for the non-IDLH tasks where departments currently require their use. Some after-action overhaul or salvage operations, non-emergency hazmat support, wildland and brush fire smoke exposure, and infection control during EMS response. New York's volunteer fire departments bear the full cost of our annual physicals, and fire departments that currently defer issuing filtering face piece respirators or that rely on the voluntary use provisions with their intended restrictions would be able to equip members more readily because of the removal of the cost and scheduling burden under paragraph E evaluations. This advances, in our view, rather than undermines worker protection. Firefighters are more likely to protect their communities and be protected against particulate exposure if the administrative cost of doing so is reduced without any corresponding reduction in the medical oversight that continues to apply to SCBA use in IDLH atmospheres. I referenced earlier the point of clarification we were looking for. FASD requests that OSHA clarify either in the preamble or to the final rule or in regulatory guidance whether the proposed amendment to paragraph E has any effect on the face piece seal requirements of paragraph G1I. I don't believe it does, but I think it's a good point of clarification. As you know, that paragraph prohibits an employer from permitting a tight-fitting face piece respirator to be worn by an employee who has facial hair that interferes with the sealing surface or valve function or any other condition that interferes with the face-to-face piece seal or valve function. These requirements govern fit and use, not medical evaluation, and nothing in the proposed rule or text or preamble as published appears to amend them. However, because paragraph G1I applies to tight-fitting facepiece respirators generally, a category that includes the tight-fitting filtering facepiece respirators and tight-fitting PAPRs, not only SCBA, we're asking for your confirmation that these fit-related prohibitions will remain fully in effect for filtering facepiece respirators and powered air purifying respirators, even where that medical evaluation under paragraph E is no longer required. Our departments are asking for a clear answer on this before they revise local policy. Firefighters with facial hair or other seal interfering conditions, in our view, should continue to be excluded from tight-fitting respirator use under the current standard, regardless of whether they've undergone a medical evaluation. And we want to ensure that the proposed rule is properly interpreted at the local level as not relaxing that independent fit-based prohibition that has long been the law of the land. I note that there have been many challenges in our state and certainly in other district courts in the Northeast that the facial hair rule compromises religious or other legitimately held beliefs, and courts have routinely deferred to OSHA and the express language of the regulation and upheld the requirements stated therein. Again, FASD appreciates the opportunity to comment and supports the proposed regulatory action as a reasonable, targeted reduction in administrative burden that leaves undisturbed the medical evaluation requirement for SCBA use in IDLH and interior structural firefighting. We respectfully request, as I just discussed, that OSHA confirm and clarify in the final rule that 1910-134 G1I and then subparagraphs A and B are completely unaffected by this rulemaking, and that they will continue to apply in full to all tight-fitting facepiece respirators, including the filtering facepiece respirators and PAPRs. On behalf of New York's volunteer firefighters, I appreciate your time and attention and welcome any questions that the panel may have. Thank you.
Thank you, Mr. Hannigan. Mr. Levinson, questions from OSHA for the witness?
Yes, Your Honor. OSHA's first question comes from Dr. Jonathan Bear.
Jonathan Bear, OSHA. Mr.
Morning,
Hannigan, thank you for your testimony. Does your association have any data on how often the medical questionnaire results in workers finding out they have a medical issue that they were previously not aware of?
So I heard that concept yesterday, and I in my own experience, I've been a volunteer fireman for 22 years and counsel departments across the state. For firehouses, it's not so much the appendix, it's not the questionnaire, it's the blood work that we have done or the stress test or some other component of the annual physical other than the questionnaire. So I mean, I've filled that questionnaire out 21 times myself, and it's they generally don't where we have found either serious cardiac conditions or conditions that our firefighters were unaware of was blood work or the stress test or some other advanced testing that the questionnaire didn't move the needle on one way or the other.
How often, when firefighters are approved to wear their FFRs and loose-fitting PAPRs, how often while they're working does the incident happen where they then have to have another medical evaluation?
I would say slim to none. Generally speaking, for interior firefighters, we even some of our exterior firefighters get the full SCBA with the tight fitting seal. I think employers now generally in New York, those being towns, villages, fire districts in the rural areas, have those other, the PAPRs are generally not included in what we do. There are some specialized hazmat teams that would have that, but we are primarily covered by that loose fitting filtering respirator. Our departments have those available, and I think if if somebody had a question about it, or was concerned about it, they wouldn't be compelled to wear it or respond with it. But I generally most use it now, and they're already compliant with the more stringent components of the respiratory protection standard. In further explanation of that, I think that in some of the comments I read about the physiological concerns where when people wear SCBAs, it can be you can feel claustrophobic or concerned. I have not experienced or been informed by any of those similar concerns or shared with respect to the loose fitting respirators at all.
Thank you very much. Those are all my questions.
Your Honor, the next question from OSHA comes from Dr. Minden Yablis.
Hello, Mr. Hannigan. I just wanted to clarify, and I think I heard it in the last answer, but it appears most of your constituents are cleared for SCBA use. Are there circumstances where they might just require clearance for a powered air purifying respirator as far as their volunteer duties?
Yeah, there could be for specialized. I would expect to see that in hazmat response. Many fire departments just incorporate SCBA and put the full hazmat suit over the air pack unit itself. I think it would be a small component. I don't know that there would be a cost savings there. Obviously, I don't know that it's substantial, but just because we have primarily SCBA use. But there would be for those departments that do have that, they would certainly experience a savings.
Thank you. This is Dr. Yablis again with a follow-on question. Would you be concerned, given you discussed hazmat, there may be high stress, high exertion, or high heat kind of scenario where they're wearing these PAPRs? Are there any concerns around that?
Yeah, I mean, I think there's a sticker on all of our helmets that firefighting is inherently dangerous, and basically, why are you doing this? So we would always have concerns about our folks going into that. The Tyvek suits can be warm, so I think that part of that medical evaluation is good. As I have concerns, but generally those teams train so often that when there's if there's going to be an incident, it would be training. But there are so many test simulations of that I think the rate of injury with respect to the use of PAPRs, or certainly the loose fitting face piece respirators, would be de minimis. And if there was some issue, we'd be able to get that person out of the zone and deconned appropriately.
Thank you. No further questions.
And Your Honor, OSHA's last questions come from Dr. Bob Blicksilver.
Hi, Bob Blicksilver, OSHA Standards and Guidance. Mr. Harrigan, does your association have any survey data, or have there been any studies within your membership on current practices with regard to respirator usage, medical clearance practices and procedures, and training on respirator usage?
I don't know that we have data on it. We could likely find, we could provide data on the number of interior firefighters in the state. So we're an OSHA plan state, so all of our interior firefighters and many of our exterior firefighters who were formerly interior continue to get the annual fit test under 1910-134. With respect to the loose fitting ones, I think our EMS component, we'd see that. During COVID, a lot of our firefighters were also, we wore masks more often, even including on the apparatus that we generally don't do. The best estimation of that, sir, would probably be the number of total firefighters, just because we know interiors do that physical process now.
Thank you, Bob Blicksilver again. Well, if in post-hearing comments you come across or you're aware of any compiled data that profile the distribution of certain types of respirators that you've described here for certain activities among firefighters, that would really be helpful to us. Thank you.
Okay. Thank you, Dr.
Thank you, Bob Blicksilver. When you screen new employees for health concerns in relation to the use of respirators, do you rely exclusively on the questionnaire in the appendix to the OSHA standard, or have you developed other means of identifying medical signs or symptoms? In post-hearing comments, could you characterize and quantify the range of costs involved with medical screening procedures? I think you touched on how you identify through blood work and other means signs and symptoms and medical conditions that your firefighters have. If you could elaborate on those, if you have any more information to share on those areas. And as I mentioned, if you can characterize and quantify the range of costs involved with the medical screening procedures. I think you mentioned administrative costs in your testimony. So if you could, again, please elaborate on that, that would be helpful to us. Thank you very
Absolutely.
much.
Yep. Thank you. Do you want me to respond now or in post-hearing on that?
If you have anything to respond now, that would, Bob,
Okay.
so that would be fine. Or otherwise, post-hearing would be fine too.
Okay. Real quickly, all departments in our state use the appendix, the questionnaire. But with respect to respirator use, I think that it's either the occupational health physician that's performing the physical, or some departments are certified in-house to do that. Either the officer performing that test, or in many cases the medical professional performing it. It's the eyes-on operation and use of that, with particular respect to SCBAs, that they will use in determining whether we're qualified or not, if there's some problem. I would note that many firefighters by nature generally try to tough it out and like I'm fine, everything's good. So I don't know that the questionnaire really prompts the types of responses that would otherwise cause some concern from physicians. Our volunteers tend to want to serve until they're 130 years old, because they love it and they serve their communities with pride. But it's generally the eyes-on, hands-on medical testing that catches stuff for our members, and that's a fair statement across the board. But I can look into the cost of it. Would be beyond just this deregulatory action. I mean, you're talking the full physical, but we could get a range of the costs on that to try to estimate it.
Sure. Thank you. Bob Licksilver again. Yeah. However you wish to characterize the cost, whatever you identify in your records, any information that you're able to gather on the different aspects of the administrative costs, and any other resource uses, any other costs of resources involved in the screening and evaluation of your firefighters. Thank you.
Absolutely. Thank you.
Your Honor, that concludes the OSHA's questions for Mr. Hannigan.
Thank you. Mr. Barrett, questions from the solicitor?
Joseph Barron from the Office of the Solicitor. I have no questions, but Mr. Hannigan, thank you for taking the time to testify today. It was much appreciated.
Absolutely. You're welcome. Thank you all.
And Mr. Hannigan, thanks very much for your service and the service of your members.
Thank you, Judge Bell.
All of us who live in communities served by volunteer firefighters and EMS really appreciate what you do. Thank you very much,
welcome, sir.
Okay.
Thank you.
All right. We have next the American Road and Transportation Builders Association.
Here we go. I am promoting to panelists Priyanka Sharma and Brad Sant. There we go. So you should have the ability to turn on your camera and your microphone. And as a reminder, we have a courtesy timer in the bottom right-hand corner of your screen.
Great, thank you. Good morning. My name is Priyanka Sharma with the American Road and Transportation Builders Association, and I believe my colleague Brad Sant is here as well.
Yes, good morning. I'm Brad Sant, and I serve as the Senior Vice President of Safety and Education for ARTBA.
Thanks very much. You all can begin your testimony when you're ready.
Thank you. So just by way of introduction, the American Road and Transportation Builders Association, or ARTBA, is a national association with over 8,000 members in transportation construction industry. Our members represent the spectrum of project delivery construction, including contractors, material suppliers, planning and design firms, safety and equipment manufacturers, public officials, and transportation research institutions. So we represent a broad swath of the industry. And just to begin, ARTBA strongly supports OSHA and its mission to protect America's workforce. Since our inception nearly 125 years ago, the safety of workers and roadway users has been an essential component of our core mission and values. And we regularly reach out to partner with OSHA through alliances and training programs, through the Federal Highway Administration as well, because we view this partnership between the private industry and government as very beneficial and important. And so we support OSHA's efforts to ensure its regulations are appropriate to protect workers in the roadway construction industry, while at the same time ensuring that they make sense for the employers to comply with them. So I appreciate OSHA's constant kind of looking out to make sure what they've done in the past continues to make sense today. So today we wish to express measured support for OSHA's proposed amendments to the medical evaluation requirements in the respiratory protection standard for certain types of respirators. And we consider the medical evaluations and the use of questionnaires where appropriate to be a best practice for filtering face piece respirators, FFRs, and loose fitting powered air purified respirators, PAPRs. While we strongly support the use of appropriate PPE for the protection of workers, the use of respiratory protection may cause a physiological or psychological burden on particular employees, and the existing medical evaluation process can help identify underlying conditions that could result in adverse effects while they're wearing those types of respiratory protection. And this includes the face filtering respirators and the loose fitting power air purified respirators. So as this proposal came out, we spoke with our members, and based on that feedback, which is probably more anecdotal than a scientific type survey, but we think OSHA could consider adding this questionnaire as a best practice, as a new non-mandatory appendix for these type of respirators. This strategy would provide our members with guidance on whether a medical evaluation might be beneficial, while allowing flexibility in situations where the process simply may be unnecessary. We also respectfully request that OSHA identify medical evaluation as a best practice in the preamble of the final rule and in the underlying regulatory text. ARPA takes the safety of our members very seriously, and as such, we evaluate any deregulatory proposal promotion with caution. In this instance, we support the proposed rule as it gives flexibility in cases where OSHA has preliminarily determined that a mandatory evaluation may not be necessary, but continues to provide information for situations where an employer may suspect or may have information that shows that this employee may need to go through that questionnaire, and they have that available to them with regards to these types of respirators. So I will turn the time over to Priyanka to follow up.
Thanks, Brad. I don't have too much to add. I just wanted to say, first, just we support your effort to provide review of these existing regulations. I think one of the unique things about the transportation construction industry is that it's constantly evolving based on changes in technology, equipment, work practices, available materials, given the scope of the project. And so I guess the only other thing we would ask is for periodic review of these standards, and that this not be the sort of one-off review and stopgap, and then it's not looked at again for another several years, especially just given the fact that we do have equipment manufacturers and safety equipment manufacturers who are constantly trying to change and evolve new technologies. We're hopeful that this will be an ongoing and evolving effort on OSHA's part to just make sure that the regulations are keeping up with these new technologies as they come online. And so with that, we're happy to answer any questions. And again, we appreciate the opportunity.
Thank you very much. Mr. Levinson, questions from OSHA?
Yes, Your Honor. First questions from OSHA come from Jonathan Bear.
Jonathan Bear, OSHA. I was wondering, how often do workers require a follow-up medical evaluation after using a respirator on the job? Do you have any? Does your organization have any information on that?
You know, we have not surveyed our membership for information on that, so I couldn't answer you specifically, but I'm not aware of that being a very common practice at all, doing follow-up.
All right, and when if you are aware of those incidents occurring, how are the employers aware that a follow-up is needed? Would that be through an actual medical incident happening, or an employee requesting another medical evaluation? How would that take place?
Well, without having, direct feedback from the members, it's really difficult to know. I suspect it would be a combination of both of those. There may be a number of circumstances that come up that would require that type of follow-up, and maybe it's something that's observed by the employer. Maybe the employee self-reports something. I mean, as you mentioned, there could be a variety of things, and we'd be glad to ask more specific questions to the membership to provide that information. But I simply, we did not survey for that.
All right, that would be excellent if you could provide that in post-hearing comments, as well as asking your membership how effective they think the questionnaire is in identifying issues where there would be a requirement for a limitation of usage for these respirators. Thank you. Those are all my questions.
Your Honor, the next questions come from Bob Blitzsilver.
Hi, Bob Blitzsilver, OSHA Standards and Guidance. Mr. Sant, does ARTBA or the Coalition of Trade Associations have any data on the prevalence of medical conditions that would lead to respirator changes or other job assignment accommodations among your employees?
And I assume when you're talking about the other coalition, when we filed comments, that was done as a group. And again,
Yes.
we did not ask that question as we, of all the group as we came together to do that. But I know we certainly could ask again, as we mentioned before, ask that question, and similarly as the coalition that signed that, see if they would be available to answer those questions as well. But again, that was not in our survey that we did as we reached those comments.
Yes, that would be helpful to us. Bob Blitzsilver again, that would be helpful to us just to identify sort of what the baseline practices are. What are the current practices with regard to identifying medical conditions and then accommodating for those conditions through job assignments or altering the respirator assignment or whatever accommodations would be given to the employees. So thank you.
Thank you.
I think that's all that I have, Andy.
All right. Your Honor, the last question from OSHA comes from me, Andy Levinson. I'm curious, I don't know if Ms. Sharma or Mr. Sant was available yesterday and watched any of the proceeding, but one of the issues that came up, and what I'm trying to get at, is this concept of best practices and some of the things you said about moving things maybe into a non-mandatory appendix, but the OSHA standards are really primarily concerned with minimum required practices. And one of the issues that was floated yesterday was the possibility of allowing employees to request medical evaluation, either following training or following fit testing, where sometimes medical issues might be discovered during those scenarios. And I wanted to know if ARTB had any thoughts on those issues from yesterday or that approach.
Yes, thank you. So I was able to listen to the testimony yesterday morning, particularly from those people who represent the construction industry. And, I think that would be a very advisable thing to do. If an employee raises some concerns, or if there's, training that goes on about the use of respirators, there certainly should be mention in that training that there is a questionnaire available, for these respirators if people have some concerns, if they have some breathing concerns. And then that should be made available should the employee raise that in those situations. So we would be definitely supportive of that. Anytime an employee may have a concern about wearing a respirator and any kind of functionality that they might have physically or psychologically, then that would be the perfect time to say, hey, this is an appropriate time to use the questionnaire just to make sure they're in the best shape to do so. So we would certainly be supportive of that.
Thank you. The only thing that I wanted to also offer, I recognize you offered comments, pre-hearing comments as part of a coalition. To the extent that any of the stakeholders in that coalition may have evolved their positions, any thoughts that you have in post-hearing comments where we can really clearly understand what ARTBA's position is on any of these issues, if they are in fact evolved since the pre-hearing comments, that would be very helpful and welcome in post-hearing comments.
Okay, thank you. Yes, we'll certainly do that.
Your Honor, that concludes the questions from OSHA.
Thank you. Mr. Barrett, questions from the solicitor?
Joseph Barrett from the Office of the Solicitor. No questions from me, but thank you for your time and testimony.
Thank you.
Are there questions for this panel from the public?
No, Your Honor, there are no questions from, we just got two raised hands. Kathy Fagan, I have enabled your mic.
Thank you. This is Dr. Kathleen Fagan. Actually, I had a question for the previous speaker, but it appeared to be an option.
He'll be coming back, so hold your question for
Oh,
him,
okay.
please.
Okay. Should I put my hand down now, or?
You can put your hand down and I'll come
Okay.
back. I'll come back to you in
Got
30
it.
seconds, I hope.
Okay.
And then I see a question from Ellie Barbarash. Ellie, I have enabled your mic as well.
Good morning. This is Ellie Barbarash from AFSCME, and my question is also for the prior speaker, so perhaps I should wait. Thank you.
Thank you.
That makes it easy.
Okay. Ms. Sharma, Mr. Sant, thank you very much for your testimony. We really appreciate it. And if it's possible for us to bring Mr. Hannigan back, we could pose the two public questions to him that got overlooked a minute ago.
Yes, Mr. Hannigan, I have promoted you to panelist.
Morning.
Thank you for coming back.
You're welcome.
All right, questions for Mr. Hannigan that I overlooked, please.
I am going to enable Dan Glucksman's mic since I saw he raised his hand before. Dan, your mic should be enabled.
Go ahead, Mr. Glucksman.
Hi, thank you. I'm Dan Glucksman with the International Safety Equipment Association. And Mr. Hannigan, in your comments, and granted, this is a little bit of a divergence from the fit testing part, but you had mentioned that the volunteer firefighters that you work with, that their job is inherently dangerous.
Yes.
And a question on that, do you feel that OSHA protections help to make work safer for these individuals and help to mitigate the inherent dangers in their job?
Yeah, I think with the current standards do. Yeah, I mean, we're an OSHA planned state, so everything that OSHA comes out with applies to us. I think certainly the respiratory protection standard as presently written is good. I also think that there is room for deregulation there. And I think FAST's position is where on this particular deregulatory action, I think it's appropriate. I think if for example, Mr. Glucksman, if they were going to say, if OSHA would say all firefighters can have full beards now, we didn't mean what we said, we'd probably have some response to that. But this on this particular topic, I think they've correctly hit the nail on the head.
Okay. Then the other one, not as weighty. What stadium is it that's covered by the volunteers?
Oh, it's the only New York team, the Buffalo Bills.
Excellent. Thank you.
You got it.
Next question from the public, please.
Okay, I am going to ask Kathy Fagan to unmute.
Thank you. This is Dr. Kathleen Fagan. Thanks for your comments, Mr. Hannigan. I wondered if you have an idea of the age range or the average age of your volunteer firefighters and what % are in kind of an older category, say 50 years of age or above?
Sure. So, Dr. Fagan, as I age, the older range gets farther and farther out. I've been in for 22 years, and I remember feeling young, and I still feel young, and I'm no longer 18. So, we definitely accept anybody who's physically fit. I could tell you in my own department, we have an exterior firefighter who is administrative capacity only, who's 88 years old. So he doesn't respond to emergencies. He reports to the firehouse and basically handles things there and coordinates the crews going out for calls. We in New York have had success with like Explorer posts or younger programs with high school age 16 and up. That's a category that's thankfully growing in our state, which is good. I'd say that the smallest category is generally people in my age bracket or just slightly younger. So college age, like 20 to 35 is where we really need to grow, and we're in a tough spot because of housing affordability. and people having young children and starting careers, it's a tough time to also pick up a volunteer job to serve the community. We do very well in, I think, the 40 to 55 bracket. And I think we do, just tracking with the baby boomer generation, have a disproportionately outsized age range there. But our 60 plus members, our age 60 plus members still perform. We have some interior firefighters that are into their mid 60s. Some of them in better shape than some of the guys my age. It really is individual specific. But those in the volunteer fire service, you generally transition from youth member with probationary restrictions to full active interior to exterior to driver. We have another subcategory of exterior firefighter called fire police, and they generally regulate, scene traffic, scene safety, shutting down the road as necessary. It's a profession that you can really age into and age well into as long as you're physically fit and healthy. But yeah, we basically cover 16 to, what is it, 88, 60, probably 80s high. It's rare that we have people in their 80s, but we do.
Thank you. And extending on that question, particularly for that, kind of 40, 50 and above, do you know what percentage of them have underlying chronic medical conditions like high blood pressure or lung disease or heart disease?
I don't have specific numbers on that. I do know that based on the nature of the work that we do, that cardiac events are generally the number one killer of paid and volunteer. Just because of the stress of the job. There's a reason why the career departments age people out after 20 years. So, but they also in the career departments lack the kind of the age in place abilities that we have, where there's lighter duty roles later on in a support capacity. So as far as individual or at a higher, I think the higher incidence of cardiac death is related to the stress of the job from when the time the tones go out. There's actually data or studies on that show that from the time that the dispatch occurs, elevated heart rate. I have no data myself other than I can tell you when we do get toned out for calls, I feel there is an adrenaline. There is a physiological change that occurs. And we had my department, we had a chief die in response to after the call. He had other aggravating factors going on there, but we just the tones cause a physiological response.
Thanks. I have one last question, kind of that I think you answered somewhat, but I was a little confused, which is what percent of your volunteer firefighters do duties that only require a filtering face piece, respirator, or loose fitting PAPR?
Sure. As far as the PAPRs, I would say probably less than 5%. The loose fitting face piece, I think you could see a little more often. We would see those with certain chiefs in jurisdictions have fire investigator responsibilities where they'd wear that instead of full SCBA. And again, this would be days after the incident. We're generally full SCBA even in salvage and overhaul. But if we're called to return to the scene, you'd have that loose fitting respirator. For EMS response, certain EMS response, they'll have loose fitting respirators on. Some volunteer fire departments provide a hybrid EMS and fire response function. Others just provide fire response. But those loose fitting respirators are there for, we could be, if you're in like the cold zone in a hazmat situation, that respirator use could be indicated there. But we'd probably see, did you ask for a percentage for the loose fitting ones?
If you have it.
Yeah, if I don't have numbers. I'm just kind of going off our experience of what I know other departments do. I'd say that the likelihood of the loose fitting is probably in like the 35 to 45% range, where at least on an ongoing basis. I think if obviously in the pandemic it would be greater, but on an ongoing basis, the EMS response, I'd say about just close to half, but just under.
Okay, that's really helpful. Thank you so much.
You're welcome, Dr. Fagan. Thank you for the question.
Other questions from the public?
Yes, Ellie Barbarash, I'm going to ask you to unmute to ask your question.
Thank you. Mr. Hannigan, thank you for your testimony, and I really want to thank you for your service, especially as someone who spent many, many, many decades in New York State.
Thank you.
I have a couple of questions. One is, in AFSCME, a lot of our members in other states are folks who repair fire equipment, whether scuba equipment, helicopters, firefighting trucks, etc. And we know that there's such a high level for you and our members of cancer because of the carcinogens in smoke. And we also know that there really is a dose-response relationship where there is no safe level for an exposure to a carcinogen. Probability any exposure of it heightens your range for cancer, and so much so that if you get, God forbid, you get or someone gets cancer, there's no challenge from workers' comp that it's work related. So I guess my first question is, do you have any sense of your statistics on inhalation based and even, or just what your cancer levels are that are fire related? I guess that would be
Yeah.
a first question for your folks.
Yeah. So thank you for the question. So in New York State, volunteer firefighters have a presumptive cancer only for lung. For other cancers, which we know have a causal relationship, there's a separate statutory scheme under New York law where authorities having jurisdiction have to buy an insurance product that provides either a diagnosis benefit or, sadly, in all of those cases, a death benefit upon the death of the volunteer firefighter. So we have less protection in New York than our career counterparts with respect to all cancers. But I know since there's a similar program in the state of Georgia that ours was modeled after. I know that as our population ages, particularly with the baby boomers, we've had more claims under that program. The data for that is held by the insurance carriers. Hartford would be one. VFIS, which is based in Pennsylvania, would be another. That would have those carriers would have the raw data immediately at their hands to know the total number of claims, but we don't know that exactly now. I do agree though that your members, to the extent they're performing work on the apparatus, particularly on the inside, we've come a long way as far as clean cab concept and washing gear and there. I mean, just since the time that I've joined, there's been a total transformation. Dirty gear used to be a badge of honor, and now people are telling you to get off the truck and don't get inside. So, but I think for your member, if they're outside the vehicle, I think the rate of I think it'd be reduced risk. Inside the vehicle, it could potentially be higher.
Okay, so thank you so much for that answer and for your work on it. But my second question is just for clarification for something you answered before, which was, and just because I thought I heard a contradiction, so I just imagine you could clear it up. So you shared that for the volunteers who may be getting up in age or just have such a profound commitment to the work as volunteers, that they may not always be forthright on that questionnaire, right?
Yeah.
They may not always be forthright on that questionnaire because they don't want to not have the opportunity to provide this service. But you also said that your statistics show that it's not very useful, that like one of your reasons for saying it's not helpful is because you don't get much response to it. But I guess that doesn't, I guess my conclusion would be that if anything, that screening questionnaire needs to be enforced and implemented with more vigor as opposed to just disregarded, because it kind of, what I hear, and I don't think you meant this, is you're saying, well, it doesn't work because people lie because they want to do the work. I mean, I just wonder if you could expand on that.
Sure. Yeah. So that was anecdotal, meaning I think everybody, all volunteer firefighters in New York State fill that out, including some exterior ones that are fit tested but will never serve the interior function. I think my comments, and to the extent I didn't convey that correctly, I'll do so now. It is other components of our annual physicals that catch the conditions that I think were addressed yesterday. It's not the questionnaire, and it's not because people aren't forthright on it. I think they are. I think that some of the older ones, again, it's more of everybody fills it out, but in our practice, it's not this questionnaire caused someone to get additional testing. It's no, the other components of the annual physical program that we built in, whether it's a cardiac stress test or advanced blood work, it's the blood work and the stress test that in our experience we have found either find a condition or discover that the condition has been exacerbated such that we have to take that volunteer offline or reduce their capacities with respect to firefighting. So I think the questionnaire is nice. I do think we get general compliance on it. I mean, I think it'd be easy enough for somebody to not, but that's the questionnaire, even when properly filled out, is not the thing that's catching unknown conditions with firefighters. It's other components that are more invasive. It's the blood work. It's the actual eyes-on, hands-on testing of firefighters where those conditions are discovered in our experience.
Thank you so much for your
You're
work
welcome.
and for your work protecting your members. Thank you.
Thank you.
Any other public questions for Mr. Hannigan?
No other questions at this time, Your Honor.
All right, Mr. Hannigan, thanks very much for coming back. It's
You're welcome.
my
Thank you,
fault.
Judge.
My fault that I overlooked public questions earlier. So thanks for your
Judges can't
help.
make mistakes, sir. You're all right. Thank you.
That's why
Take
we have
care.
appellate. That's why we have appellate courts. All right, Society of Chemical Manufacturers and Affiliates.
Yes, I am promoting Cedra Beckman. There we go. And Javier Barajas Martinez. I promoted you both to panelists. You should receive an invite and should be able to unmute and turn your cameras on when you're ready.
Good morning.
Good morning.
My
Welcome.
Thank you. My name is Javier Barajas Martinez, and I serve as Vice President of Government Relations for the Society of Chemical Manufacturers and Affiliates, also known as SOCMA. Joining me today is Cedra Beckman, Health, Safety and Environmental Manager for CJB Industries, and Chair of SOCMA's Health and Safety Committee. SOCMA represents approximately 150 companies across the specialty chemical industry. Our members operate sophisticated manufacturing facilities where protecting employees is the core responsibility. Through SOCMA's Chem Stewards program, manufacturer members implement environmental, health, safety, and security management systems focused on continuous improvement and risk-based control. SOCMA supports OSHA's proposed amendment because it provides targeted flexibility while maintaining strong worker protections. We believe regulatory requirements should reflect the type of respirator being used and circumstances of its use. Rather than speak about the principle only in abstract, we wanted OSHA to hear directly from one of our member companies about the existing requirement, how the existing requirement operates in practice. I will now turn it over to Cedra.
Javier, thank you. And thank you, OSHA, for the opportunity to share our experience. I'm Cedra Beckman, Health, Safety, and Environmental Manager for CJB Industries in Valdosta, Georgia. CJB Industries is a family-owned specialty and agricultural chemical contract manufacturer that relies on a well-trained workforce to safely manufacture and formulate chemical products for its customers. Safety is an important part of how we operate. CJB participates in SOCMA Chem Stewards Environmental Health and Safety and Security Program, and our facilities have been recognized for proactive safety practices. It is from that perspective that we support OSHA's proposal to remove the medical evaluation questionnaire requirement for employees who only use filtering face-piece respirators, including N95s, R95s, or loose-fitting air-powered purifying respirators. This is not about reducing worker protection. Indeed, we fully support maintaining hazard assessments, respirator training, fit testing where required, proper respirator selection, and comprehensive respirator protection programs. Those are important controls that directly protect our employees. For CJB, however, the proposed change would have a significant practical impact. We estimate this change would remove the medical evaluation requirement for approximately 82% of our employees, or about 164 of our approximately 200 person workforce. who otherwise undergo the process because at some point in time they may wear an N95 or similar respirator. At approximately $65 per evaluation, that represents roughly $10,660 in direct savings. Beyond those direct savings, the change would also eliminate at least 320 hours of employee administrative time per evaluation cycle if we were to go through all of our employees. Resources that could be redirected toward higher value safety activities, including employee training, hazard assessments, and field engagement. We recognize concerns about employees with underlying cardiovascular, respiratory, and other medical conditions. Supporting this proposal does not disregard those risks or mean medical evaluations have no value, but the requirement should reflect the type of respirator and circumstances of use. Medical evaluations can remain an important tool where appropriate. At the same time, employers should have greater flexibility for the respirators covered by this proposal and continue meeting the core requirements of an effective respiratory protection program. Based on our experience, this targeted and practical update will remove an unnecessary administrative burden for a substantial portion of our workforce while preserving the respiratory protection measures with the greatest impact on employee safety and health. We encourage OSHA to move forward with this proposal. Thank you.
Thank you. Questions for this panel, Mr. Levinson from OSHA?
Yes, Your Honor. First questions come from Jonathan Bear.
Jonathan Bear, OSHA. This is a question, I believe, for Ms. Beckman. Do you or your association have any data on how often medical questionnaires result in workers finding out that they have a medical issue that they previously were not aware of?
We can put a poll out to our Health and Safety Committee to ask that question. I can speak from my own experience being at CJB for 15 years in my role. We have not had somebody come through the medical questionnaire found that they had an issue. So we also do post-hire physicals for our employees. And so if we were to have something pop up, it's usually in that post-hire physical that we find those things out.
And I had one other question. Do your workers face any hazards or perform any tasks when wearing an FFR or loose-fitting PAPR that would prevent them from being able to momentarily take their respirator off safely? For instance, if they were feeling any symptoms like shortness of breath or any sort of discomfort?
So we are a batch manufacturer, so a lot of what we do, and I can only speak for our company, not our members, and we can ask them the same question, but our employees are doing some manual tasks where they are possibly exposed to powders is our biggest issue that we wear respirators for. So they could definitely step back and step away from that process for the moment, take a breath when they need to if they feel overcome. We find that our employees that are actually wearing the PAPRs enjoy those, especially here in South Georgia. So summer months, having a little bit of air blowing and getting a vortex cooler on there helps cool them down, and they tend to enjoy wearing those loose-fitting respirators.
Thank you. Those are all my questions.
Your Honor, the next questions from OSHA come from Minda Nieblas.
Yes, this is Dr. Minda Nieblas. This question is for both panelists or whoever would like to step in. I'd like to hear a little bit more about the type of workload or exposures that workers are exposed to while wearing either filtering face piece respirators or PAPRs. You mentioned powders. Are they wearing them all day? I'm asking because we understand more from yesterday's testimony about what healthcare workers are using these for. I'm interested in your employees.
We can also ask this of our membership as far as the Health and Safety Committee. As far as my company, it's not constant. So it'll be maybe an hour. They'll step away and do a different task. Our PPE is based on the hazard So the chemical hazard at the moment, and so different parts of the batch require different PPE. At some point, they might only have on an apron and sleeves. They might not need to have a respirator on, depending on what's going into the batch.
Thank you. I have a follow-on question. This is again Dr. Mendinioblis. Do you have any information about how often a worker may require going back for a medical evaluation after using their respirator on the job?
We can pose that question to membership again. I can only speak from my company, and we have not sent anybody back.
Okay, thank you very much. And I have one more question. You mentioned both FFRs and powered air purifying respirators. Is the use of the powered air purifying respirator due to a recommendation from the questionnaire, or is the use of the powered air purifying respirator due to the hazard? I just wanted to know a little bit more about the context of using the powered air purifying respirators.
For us, it's based on the hazard assessment.
Thank you.
You're welcome.
Your Honor, the next questions from OSHA come from Bob Blicksilver.
Hi, Bob Blicksilver, OSHA Standards and Guidance. It sounds like you're going to be having some time to survey your membership during the post-hearing comment time. And I wonder if I could suggest a few other questions to include in that survey. You mentioned operational efficiencies. You described that broadly in your written comments, operational efficiencies from streamlining the questionnaire process to identify medical conditions. Do you have any anecdotal testimonials or survey data on potential cost savings identified by your members from reducing those administrative expenses? So that's sort of a part A of my request. I'll just pause here and see if you have a response.
So Javier, I guess I can jump in again and just say that we can put that out there to our membership.
Yeah, that's definitely on our radar. We heard from the previous discussion earlier today and yesterday, and we will follow up with post-hearing testimony.
Okay, and thank you. Bob Blicksilver again. I wonder if you could ask also if your members have identified any or could potentially identify any hidden costs from eliminating the medical questionnaire, and then medical conditions arise, they discover them, and that leads to workers' compensation issues and disruptions in production and the reassignment of employees and decisions about respirators, all of these administrative and resource expenses that employers may incur as a result of not identifying the medical condition through the questionnaire. I wonder if you can include those types of questions in your survey of your membership.
Certainly will do.
Thank you very much. That's all I have. Thank you.
Your Honor, the last questions from OSHA come from me, Andy Levinson, and my question it centers on the phrase that you use, Ms. Beckman, that you support medical evaluations where appropriate. And so what I wanted to explore and see if you have thoughts either now or in post-hearing comments, some folks yesterday raised the issue of potentially adding back in a medical evaluation either after training or after fit testing where the employee or the supervisor had perhaps identified a need for medical evaluation. And so if you have any thoughts on that, that would be very much appreciated. And or what, in the context of loose fitting PAPRs and filtering face pieces, medical evaluations where appropriate, what you think that means.
So yes, going back to some of the comments and even the comments I've heard today about maybe being a best practice, or if it is, during a fit test that an employee realizes there's something that's not quite right, having that available as an appendix for them to use and actually take back to the medical examiner.
Thank you very much. Your Honor, that concludes the questions from OSHA.
Thank you. Mr. Barrett, questions from the solicitor?
Yes, Your Honor. Joseph Barrett from the Office of the Solicitor. I guess this question kind of goes to both of you and maybe employer specific or to your membership generally, either now or in post-hearing comment. Do you or other members have any information about how often medical questionnaires for FFRs and loose-fitting PAPRs are currently resulting in further medical evaluations or subsequent limitations on respirator use? I don't know, Ms. Beckman, if you have thoughts on that anecdotally or just in your experience, or otherwise, I mean, I'm perfectly understand if it's better for post-hearing.
Definitely better for us to get some information from our members, but also we haven't had any in the 15 years.
Okay. And one thing that was kind of came up with some of the witnesses yesterday, and in your experience, I mean, I think you just kind of said something about this. Do you find that the fit testing procedure ends up being, some people said that they thought the fit testing process was actually a better place to sort of identify some of these issues, and that's where they were more likely to find an issue with the respirator use. Has that been your experience?
So we haven't found any type of cardiovascular or respiratory issues with the fit testing. We have found claustrophobia, and we have found some PTSD actually during that process, which has been interesting.
Okay. And then what type of professional is conducting the fit testing? Is it a medical professional? Is it, I guess I'm just curious as to who you have conducting fit testing procedures.
So we do use medical professional.
Okay. I have no further questions, Your Honor. Thank you for your time.
Are there questions from the public for this panel?
No questions from the public, Your Honor.
All right. Thank you very much for your testimony. We appreciate you being here and answering all of the questions and providing your testimony. Very much appreciated.
Thank you.
All right. Dr. Harbour seems to be our next presenter.
All right, Dr. Harbour, I have promoted you to panelist. You can unmute and turn your camera on when you're ready.
Now, can you hear me and see me?
We can hear you. I can't see you quite yet.
Well,
Do you have a cover over your camera by any chance?
no,
There we
there
go.
we are. Thank you very much. That's been very helpful.
Okay. Thank you. You can begin when you like.
Thank you. It's a pleasure to be here, and I appreciate the opportunity to speak. My name is Philip Harbour. I'm currently at the University of Arizona. I previously was at UCLA, where I was chief of occupational environmental medicine in the in the School of Medicine. I got interested in respiratory protection when I was doing my fellowships in occupational medicine and pulmonary medicine at Hopkins. I saw 3 patients one afternoon in clinic who worked in a heavy industry, said they can't stand their respirator. I did very extensive testing. That was in the days when we could do that. Could not find a good reason. And since then, for probably 40 years, I've been interested and done many research studies, both in laboratory and in field settings for respirator work. Much of the work has been summarized, including by Dr. McClellan yesterday. I've included several recent publications in the materials that have been submitted. Next slide, please. Now, I hope you will consider these items. First of all, do not eliminate the medical evaluation requirement, but rather make it better. Many testifiers already, starting with Ms. Rendell, number 1 yesterday, and going through, have said there are serious problems with the current system. This is an opportunity to fix some problems. So I would eliminate the need to do an evaluation on every single FFR user, but rather make it stronger that those who need it get it. That includes giving them a mandatory written notice to worker that an evaluation is available with no prejudice and no cost, and specifying the process. Do this on initial assignment and at least annually at the fit test. This will have the advantage of increasing access. Currently, many people view the questionnaire-based evaluation as a one and done. That's the reality, and that's not a very good idea. I do think, for reasons I'll discuss, that PAPR users should be required to have a medical evaluation. As Dr. McClellan mentioned, and I discussed in detail in the paper based on the study, there's a lot in the questionnaire that needs to be fixed. But most importantly, we should be careful about believing that the questionnaire somehow has great predictive ability. We need to do research. I don't think, however, it's advisable to say, let's do research and do nothing until that's done. For those who work with large studies, I have a little bit of experience with that, you're talking about a 5-year delay. I think we should do studies, but I don't think we should delay changes. Now, there is very limited or almost no data that the current medical evaluations done routinely, not for cause, not for symptoms, are useful. In addition to that, the concepts underlying them are 50 years old and were developed at a time that there were no N95s. Respirators were big, bulky, and high resistance. That's not the way they are now. In addition, much of the original work that the standard and the procedures were based on was based on studies of Navy scuba divers, maximal exertion levels, etc. They are not particularly relevant or accurate at the current time. The fundamental basis for the current system for the FFR users goes on the hypothesis, is predicated on the hypothesis that if you know the disease, you know whether they can use a respirator. On the other hand, as Dr. Beckett and I discussed in one of the papers, you have to carefully consider the work site and the individual's adjustment to it, as well as the respirator, not just the list of diseases, which is where it came from, starting a list provided by ANSI. So that I think it's time for a change. And we have to recognize, as has been pointed out by others, and we found in our survey that's in the materials submitted, that the problem is not just pulmonary limitation, breathing through a resistance anymore. It's heat, particularly with longer use, skin problems. Acceptability, not physiologic limitation, is a significant factor, and that needs to be assessed carefully. Psychological problems were also prominent in the survey we did. Now, I must say the survey has significant limitations and needs to be extended. There are reasons to make a change now. Many of the speakers, testifiers, have presented information that there are serious problems with access and there are problems with quality of the evaluations. When the standard was changed in 1999, NIOSH actually formally opposed certain of the changes, relying on a broad array of plicketies and a questionnaire. The current system is not working. And as I said, I don't think we should say, let's keep it in place, do research, and 5 years from now, consider it again. Let's also focus on why we do these. We do them to predict the future. Now, this is a screening examination, not a diagnostic evaluation. That means that by usual criteria for is screening useful, the goal is to find a problem before it would become important otherwise. I think in this situation, there definitely will be problems identified when workers or fit testers report potential problems. The question is that way too late? Now, going further, we have to ask, and this is really a policy question. I know that Dr. McClellan and I actually raised this in a technical question to the directorate several years ago. whether the evaluation should focus on the ability to use a respirator, or whether it's appropriate or necessary to look at other things. Now, absolutely, it's a good idea to do examinations to find hypertension and diabetes, ask about cigarette smoking for health promotion. The question is not whether that's useful, not whether contact with an occupational health professional is useful, but rather is it contributory for every person using an FFR. Now, moving ahead to PAPRs. Unlike FFRs, I think PAPR users should be more carefully evaluated. Why? Two main reasons. First of all, there's usually a problem. You use a PAPR because there's a health condition or an exposure condition. You use a you use a PAPR because you think the person is at greater risk. They're immunosuppressed, they have an allergy, or they're having symptoms. Now, symptoms need to be evaluated. It's not enough to say I'm uncomfortable, but you want to find the cause. Again, we discussed this in one of our papers. Or they have a greater exposure, just as the prior testifier pointed out. It's exposure driven. It's driven by higher exposures, such as aerosol generating procedures, high heat, and things like that. Another concern, particularly in healthcare, and that's the business that I'm in as a clinician, you go in and out of rooms pretty quickly, not just doctors, but dietitians, dietary staff, etc. It's a lot easier to grab an FFR outside a room, don it properly, spend your 2 minutes in the room and get out. Then go down the hall, find a PAPR, put it on, etc. I strongly suspect, without strong data, frankly, that protection will actually be decreased if it's required to, when you have to rely on a PAPR. So for these reasons, both the personal health risks or the exposure risk, I think PAPR users need to be evaluated. So in summary, I think we need to make the changes now. I think we need to improve the quality of examinations by focusing them. It will help to improve the quality because the examiners, the evaluators will have to focus on the specific workplace conditions. I also think there are objections. What I'm suggesting is not deregulation per se, but it's better regulation. And I think it may have reduced costs, but that's not the purpose. The purpose is improving. Now, many people say, well, the FFR user might get a breath or two of something bad. Well, the fact is, if FFRs get dislodged pretty easily, you sweat, they move around. If that's the highest risk, then FFR is inappropriate. So in summary, I would like to thank you for the opportunity to speak. And if you go to the last slide, there are, on the last slide, please. Oh, your numbers, there we are. There are several references that I've included. They're papers that I've written because they reflect my thoughts. They're not necessarily the most profound, but they are ones that I've worked with. I'd like to thank Dr. Bill Beckett, who contributed and worked with me on 3 of them, and Dr. McClellan and other members of the ACOM team who worked on the survey study and our OSHA questionnaire critique. Thank you.
Thank you, Dr. Harbour. And I want to make sure that the slide deck that we saw excerpts from is part of the record. Mr. Barrett, do you know the answer to that?
Hello, Your Honor. Yes, I was going to do that before my questions, but we could do it right now. Sorry, this is Joseph Barron from the Office of the Solicitor. I would like to move to designate the PowerPoint presentation used during this witness's testimony as Exhibit 5.
Without objection, Dr. Harbour's PowerPoint deck is designated as Exhibit 5. Thanks very much.
Thank you, Your Honor.
Mr. Levinson, questions from OSHA for Dr. Harbour?
Yes, Your Honor. The first questions come from Dr. Minden-Nieblas.
Yes, this is Dr. Minden-Nieblas. Thank you, Dr. Harbour, for your presentation. I had a follow-on question, wondering, based on your clinical experience or anecdotes or any studies that you've reviewed, Are you aware of, or have you ever treated any adverse medical events or conditions caused or exacerbated by either an FFR or a PAPR's use?
Yes, I would say that there are a limited number of published studies that are largely anecdotal, but the literature is frankly needs to be supplemented. I must say that we submitted an R01 grant application a decade ago to NIOSH to do it, but it unfortunately wasn't funded. Now, so I'm speaking from clinical experience. There are a lot of people who find FFRs to be uncomfortable. We studied in the laboratory people with asthma, with chronic bronchitis, with upper airway disorders, and most of them tolerated it well. However, in clinical experience, you find some people who say it's a real problem. Sometimes there's a physiologic basis. Sometimes, particularly for prolonged use with an FFR, the heat itself at the face, not total body heat exposure, is a problem. In one of our laboratory studies, we compared FFRs to dual cartridge half masks, etc. And the FFRs were much better tolerated, including in the people with disease. The only thing of the multi-domains we looked at was heat was worse with the FFR, which is probably no surprise from anybody who's used one. Occasionally, you find somebody who actually has psychological concerns with it. The arbitrary 10% of people have claustrophobia belief. If you read the literature, going back to when that started, that was intentionally an arbitrary number. They said, well, 10% of people have psychological problems, so 10% must be here. I haven't found that to be that often, but there are some people who have trouble. In addition, Dr. Beckett and I looked at anecdotally why people say they have poor tolerability. And we subclassify it. Sometimes there's increased sensation. Sometimes it has to do with, do you consider it acceptable? Dr. Stella Hines, who until recently was at NIOSH, did an important study, small but relevant, where she asked nurses, which kind of respirator would you like? And if it's just well, it might be TB, they don't want a complex one, but they're willing to tolerate a lot more when she asks them, what if it's, I think, multi-resistant tuberculosis, etc. So your acceptability becomes important. Now, social context becomes important. Back 50 years ago, in a forgotten paper, Dr. Mary K. White looked at spray painters. Now, these were not FFR users, but whether your coworkers used them and the social pressure changed your acceptability, or whether you're just like firefighters, you weren't a real firefighter if you had to use an SCBA during cleanup, whereas now you're not a real firefighter if you don't use it. So you need to find out the reason. And so, yes, I found problems, but I believe that the problems should be diagnosed. Many of them are treatable. My only question is, how have I ever found anybody who put it on, immediately fell over dead? No. My understanding that the cases where that have occurred, again, OSHA, I believe, collects reports, was with supplied air respirators with a cross connect, supplying nitrogen instead of air, etc. So, yes, there are reasons, but I think that asking somebody to report symptoms would be a good way to do it.
Thank you. I'd also like to know, are there questions in the current questionnaire that you think are useful in predicting health outcomes for workers who would be wearing an FFR or a PAPR?
Yes, in the published paper, again, not profound, but I set this up with a working group, and we asked the working group to rate whether you think it's useful and whether you think it's well worded. Some were worded poorly, but were useful. It's clearly useful to ask, have you had problems? That unfortunately doesn't apply to new users because they have no experience. Other things that are clinically useful are whether or not you've got significant skin problems. Now, advanced cardiopulmonary disease is going to be important, but usually you don't need a questionnaire to identify it. Now, again, I personally think that asthma may be of the respiratory disease, the one of most concern. You don't find that on routine exams because people with asthma tend to have intermittent symptoms. So just if they're triggering an attack, that's the person who may take the mask off while they're exposed to something. That's a particular concern with half masks, full masks, etc. In the FFR, if you have bad asthma, you probably shouldn't be using an FFR, even if it's dust per se, low levels of a non-specific dust. So yes, I think there are a few questions that are useful, but I think it should be determined empirically
Thank you.
and not rely just on somebody's opinion. Thank you.
Thank you. That's all I have.
Thank you.
Your Honor, the next questions from OSHA come from Dr. Jonathan Bear.
Jonathan Bear, OSHA. I guess we're building off of what was previously asked. How often do you think workers find out that they have conditions that they didn't know about just through the questionnaire? Or do they already know what conditions they already have?
Well, if you don't know you have something, you're not going to check it on the questionnaire. So if you've got hypertension, high blood pressure, but you don't know it, you're probably not going to check the box on the questionnaire. So occasionally somebody will have something where it seemed like a minor symptom to them, but it might be important for their general medical care, not specifically for respirator use. But I imagine that's pretty unusual. Much of the literature on when you're going to find things really is covered by the USPTF, U.S. Preventive Task Force, that looks at screening general populations. And NIOSH has done a lot of work recently through Total Worker Health, looking at things other than work-related things. But the answer to your question is probably not very often, per se.
And I had one other question. You were mentioning how medical evaluation should be required for all loose-fitting PAPR users. And I was wondering, outside of situations where we know there's medical conditions that result in that selection, are there other considerations? And particularly what I'm interested in, if you look at Germany's G26, they have a threshold of 3 kilograms, whereas they require medical examinations if the PAPR is more than 3 kilograms, but do not require that if it's less than 3 kilograms. Do you have any thoughts on that?
Yes, well, that's looking at one specific problem. Can you carry the weight of the PAPR? And I don't know the German in detail. Obviously, PAPRs are constructed differently. Some put a lot of the weight on the top of the head, some are on the belt, etc. But that's only one consideration. I think there's a lot more than the PAPR. And as I said, with the exception of people who use a PAPR for a religious or personal belief exemption because of facial hair, etc., there's usually a reason. It's usually because somebody's immunosuppressed or has an allergy or is perceived to, or because, as the prior testifier from the Southern Chemical Company reports, there's concern about exposure. Certainly, aerosol generating procedures are well known to generally warrant a PAPR.
Thank you. Those are all my questions.
Thank you.
And Your Honor, the last question from OSHA comes from Dr. Bob Blicksilver.
Hi, Bob Blicksilver, OSHA Standards and Guidance. Dr. Harbour, do you or your colleagues, your teams of researchers, have any data that would help OSHA refine its profile of respirator usage, specifically the profile of filtered respirators and PAPRs? filtered face piece respirators, excuse me, and PAPRs. It sounds like you've done a considerable amount of research in healthcare and social services, for example. So have you conducted any studies to profile the usage of these types of respirators, or are you aware of any other studies? We're just trying to be sure that we've collected all the relevant and up-to-date studies, survey data on profile of respirators.
Sure. We did essentially a pilot study that's published. The results, however, are limited and should not be overinterpreted because we only got results on essentially a convenient sample. That's overweighted with healthcare and overweighted with healthcare systems where the medical officers agreed to participate. More importantly, about 20 years ago, NIOSH, working with the Bureau of Labor Statistics, did an industry-wide wide study. It's outdated. It missed a lot of things, but it provided a lot of information about the fact that only and I'm sure you're more knowledgeable about it than me, only a limited number of people were having any evaluation. Of course, that's ancient history. Now, about 4 or 5 years ago, NIOSH embarked on a smaller version of that. Again, I believe it was, this time not with BLS, but I believe they contracted this with another contractor. I believe it may have been Westat again, but I don't have expertise in this. To my knowledge, that repeat of the mini version of the old BLS study has not been completed, but that's probably the best place for you to look at this time.
Great, thank you. We will search it out. Bob Licksilver, thank you very much, Dr. Harper.
Thank you.
Your Honor, this is Andy Levinson for OSHA. I actually have one more follow-up question for Dr. Harper. I wanted to probe this issue of loose-fitting PAPRs a little bit more. So you'd stated that kind of the two primary categories for why people would be in a PAPR would be some sort of medical accommodation or a higher exposure scenario where they need a higher assigned protection factor. And there's kind of this third category that you'd not spent a lot of time on, but OSHA is aware that there are some people who wear PAPRs simply for the comfort. It is the cooling air of a loose-fitting PAPR. It is less physiologically burdensome, etc. In those scenarios where somebody either has kind of facial hair and or religious reason where there's no kind of underlying medical condition or exposure scenario, but they're doing it for kind of comfort and or ease of compliance, is there a physiologic need for some higher level of screening for those folks, the medical screening questionnaire in those scenarios?
Well, I think there's a good reason to consider it. If PAPR use was totally benign and had absolutely no problems, the answer would be no, choose what you like. However, besides the cost, I really do think, as somebody who frequently goes in and out of a patient room for a 2-minute, how you doing? Let me listen to your lungs visit. They're not going to get used that much, I believe. Now, Dr. Harrison, who's speaking this afternoon, did a survey of an old survey of quality of protection against multiple drug-resistant organisms and protective procedures. And as he points out in his paper, even the hospitals that volunteered, which were probably disproportionately good, had really serious problems. So I suspect that PAPR use probably has a lot of not being used all the time in healthcare settings. Certainly, if you're doing an 1.5-hour bronchoscopy, you'll put it on. But if you're doing a 1-minute visit, I wonder how often this is going to happen. As to why they should be looked at if it's just comfort, the reason is that you need to make a diagnosis. Why do you feel you need it? Again, Dr. Beckett and I, in the paper on suggested updated approach to the medical aspects, identify various causes of why you might want it. Some of it may be that you have increased sensation of breathing. Some of it may be that may be contextual. You're afraid, you have a lot of fear about the job, and worker counseling may be helpful. So you need to I think you need to make a diagnosis of why it's used. If it's purely for comfort and there's adverse no adverse effect of using a PAPR, sure, why not? But I do think there are potentially adverse effects, whether from the weight, whether from not using it enough, etc. Some people actually, if it's only used occasionally, the battery may be run down. So there are a lot of reasons to consider it carefully. And that's one of the reasons why I suggest don't just write them off and say, well, they have lower airflow resistance, because that's not the usual problem nowadays anyway.
Sure. Just to anchor this in a more concrete non-healthcare setting. For example, OSHA has been asked repeatedly by the asbestos abatement industry, where people are doing asbestos abatement all day long in construction settings, that for tolerability, comfort, etc., right? That in those scenarios, people would like to be able to wear loose-fitting PAPRs or other sorts of, manufacturing environments where it's not kind of the in and out of hospital room scenarios. So there are some other, work settings that OSHA is considering. That is all the questions, Your Honor, from OSHA.
Thank you. Questions from the solicitor?
Joseph Barrett from the Office of the Solicitor. No questions for me. Thank you, Dr. Harbour.
Thank you.
Do we have questions from the public?
Yes, Judge Bell, we have 2 so far. Ellie Barbarash, I have enabled your mic.
Thank you very much. And Dr. Harbour, thank you for your work and for your testimony. I think I heard you say that instead of, my understanding of the 1910-134 as it is now is if your average worker goes to their employer and says they are they want more screening, and if they actually say, I want a PAPR, I am uncomfortable working and breathing in an FFR, they have the right to have one. And certainly in AFSCME, our members have used that, as I testified about yesterday. But I think I heard you say that you would want to remove the right of workers to get a PAPR upon request, and rather they would have to justify by a medical threshold permission to use a PAPR. And you did talk about lots of, valid medical things that would justify that, but I just wonder if you could address the concern of who would be doing that justification. Are they actually a third party? I'm thinking of all the workers' comp denials in the world. I just am I'm really concerned about that as something that would be used to disempower workers to protect themselves in situations where they are already dealing with a lot of precarity. Thank you.
I agree. We absolutely must assure that a worker has access to a PAPR or other accommodation, such as work schedule adjustment or various other approaches when it is necessary. I think that I would suggest further enshrining the right to be evaluated by requiring written notice on a regular basis, as discussed, and do it in a way that you probably don't need to go through your employer and say, I'm sick, and PS, what's wrong with you? I think it's absolutely essential to provide that access. Now, whether it should be a choice to use a PAPR on a totally arbitrary basis, that is, I think I want one, I think should also take into account some of the industrial hygiene expertise and some health expertise. It may be the industrial hygienists feel that it's not the best thing based upon the exposure. There are times when PAPRs really may not be as good as an FFR. But I agree that the person should have the right to ask for it. And if the evaluator says, yes, it makes a lot of sense that you have significant discomfort, this puts you at risk of not using the device or not performing well in the job to work efficiently or protect yourself, then by all means, you should continue it. So we do need qualified and objective and independent evaluators. But I don't think it's always advisable to say, well, I want it and therefore I get it. But I think it should have a low threshold, but not automatic, because it may not be the best thing sometimes.
Thank you. I have one follow-on question that kind of synthesizes a lot of things said. And I will just say for the record, I strongly hope that workers still have the right to get a PAPR upon request. From what I understand of the difference of a loose-fitting PAPR and a tight-fitting PAPR and an N95 or an RP99, most negative pressure respirators and most PAPRs have a minimum of HEPA filtration, which are screening out 99.97% of particles 0.3 microns or larger, and an N95 is 95% and quite a lot more exposure for things like carcinogens. The issue, and PAPRs are appropriate where you're not worried about someone having a hugely hazardous exposure if their battery dies, because if that's when you need a tight fitting PAPR so that they have access to rescue filtration when they get out of the space. And that's why a loose fitting PAPR and an FFR are totally inappropriate for asbestos work, for a carcinogen for which there is cumulative exposure and no safe level. I just wonder if you could address that issue. You did address it when you said, for example, somebody intubating or doing something generating high aerosols should not be in an FFR, should be in something with better protection. Thank you. That's my last question.
Yes, I think you raised a very important point. A PAPR is not a PAPR, is not a PAPR. There are different types. Even for loose-fitting ones, there are different designs. The manufacturers produce many different types. Some have actually a fairly low, fairly high end of the hood. Others go down much further. There is concern at very high exertion rates. Dr. Ed Sinkwell I believe he's at RHD in NIOSH, but he may be an NPPTL, did a study in the past showing that if you're doing very high exertion, you can actually overbreathe it. In other words, the device has to blow air downward faster than you're sucking air up. Well, if you're sucking air in at a higher flow rate than instantaneous flow rate, then it's blowing down, you're obviously going to be potentially contaminated. Now that, of course, occurs at very high levels. But I agree with you, there are many different kinds of PAPRs, and there are many different kinds of loose-fitting PAPRs, which again is why I think somebody should evaluate, is it the right thing? I focused on a health evaluation, but as you point out, an IH evaluation may be appropriate also, rather than simply picking one and using it. But thank you for bringing up the fact that that there are so many different types and that they're not routinely protective.
Thank you.
Other questions from the public?
Yes, Judge Bell, there is Kathy Fagan. I have enabled your mic.
Thank you. This is Dr. Kathleen Fagan. Hi, Dr. Harbour.
Hi, Kathy.
Hey. So you're recommending, I believe, that there are better ways to do medical screening to prevent adverse health effects from the use of FFRs and loose-fitting PAPRs, and that OSHA could does not need to wait for long-term research studies, and that there's things that can be done more quickly. But I also think you're not suggesting that the present proposal fits that bill. So how would you recommend that OSHA proceed to go about figuring out the best ways to do these medical screenings?
Well, most everybody agrees that something needs to change. And frankly, to say, let's do a quote unquote large epidemiological study, close quote, really reflects a long delay. In the survey paper, I put in a big section about possible study designs. A prospective cohort is probably not necessarily the best way to do it, but we probably shouldn't go off in that direction right now. But again, I think that the research should get started. More importantly, what should we do now? We should mandate and enforce the mandate that everybody be given written notice, preferably written notice that specifies if you think you have a problem, this is the healthcare provider you should contact. In other words, pre-specify the method, not put the employer in the middle to say, well, you don't look so bad to me. That's step number one to really improve things. I do think that by reducing the overall number of people getting questionnaires, those who do end up requiring evaluation will be evaluated in more detail, preferably by somebody who has considerable expertise in knowing the different types of FFRs. I suspect that some evaluators may not distinguish an N99 from an N95, for example. We should remember that NIOSH was opposed to the 1999 change. The director specifically put comments in a letter to OSHA. So I think those are the changes that should be done soon. And of course, to help that along, I think a working group, an advisory group should be established, whether through OSHA itself, whether through an organization like the American Thoracic Society. I should say that my first committee I chaired for the ATS was establishing a respirator policy a long time ago, or through ACOM or AAOHN, but clearly a working group should be established to provide advice, or perhaps AOEC. There are a number of groups that could facilitate this, but I think it needs a little impetus from OSHA and probably from NIOSH to get it going. Dr. Fagan, does that address your question?
Yes, it does. Thank you very much.
Thank
Other
you.
questions? Other questions from the public?
No other questions from the public, Your Honor.
All right, Dr. Harbour, thank you very much for your testimony. We appreciate it.
Thank you.
Can we promote Ms. Crisp, please?
Yeah. I do not see Miss Crisp online. If you are here, could you raise your hand?
All right, I'm not seeing a hand raised. Ms. Crisp, the hand raising is at the bottom of your screen in the middle. If you're here, please raise your hand for us. All right, if we hear from Ms. Crisp, we can invite her back this afternoon, but it appears that she's not here now. Okay. Well, I don't think she's going to be joining us. It's 11:25 Eastern Time. We'll take our lunch break now. I don't think we have time for a 12-course tasting lunch, but hopefully an hour and a half break will be welcome. We'll be back at 1 o'clock Eastern Time. Let's go off the record, please.
Katie, are you on?
Yes, I am.
I just wanted to confirm, I just out of curiosity went to the live stream and it shows the video for Judge Bell. I just wanted to, when we go on these breaks, is the audio silenced on the live stream?
Yes.
Okay. I just want to make sure we're not in a situation where somebody could accidentally have their mic unmuted and say something during lunch that they didn't intend to be live
Nope.
streamed.
Thank you. Thank you for checking. I've been monitoring the mics.
Thank you so much.
I was singing opera selections. So I hope no one was offended.
I'm sorry you missed it.
Our viewership on YouTube jumped.
From 3 to 4. Have we heard from Ms. Crisp?
No, not yet.
Okay.
And sorry, Katie, just to double check, can they hear us now? Because Leanne is telling me she can hear us on YouTube.
Yes, now that you're unmuted.
Got it. So we do need, you keep an eye on it, but we do need to make sure that our mics are muted when we go on break. Otherwise, people could hear us on the live stream.
Yes, when we went on break, I didn't even have to mute people, but I saw all the microphones were muted.
Got it. Okay. Thank you.
Mm-hmm. All right, looks like we are at top of the hour. Welcome back, everybody. Yes, would you like me to read through the Zoom housekeeping again, or would you like to get started?
I'd like to get started, please.
Perfect.
All right, we're back on the record. It's 1 o'clock Eastern time, and we are ready for Dr. Markovitz.
Here we go, Dr. Markovitz. I have just promoted you to panelist.
Okay, good afternoon, members of the OSHA panel. My name is Charlie McAvoy, and I'm a pulmonary and critical care physician, medical director of Health Partners Asthma Center, and an associate professor of medicine at the University of Minnesota. Throughout my career, I've cared for patients with asthma, COPD, pulmonary fibrosis, pulmonary hypertension, heart failure, coronary artery disease, and many other cardiopulmonary conditions that affect a person's ability to tolerate physical stress and respiratory challenges. I am here today to oppose the proposed rule to amend the respiratory protection standard and support the continued requirement for medical evaluation of employees who are required to wear respirators, including N95 filtering face piece respirators, full face respirators, and powered air purified respirators or PAPRs. My central message today is simple. Medical evaluations are not an administrative burden. They are a worker safety measure. Respirators are intended to protect workers from harm. Medical evaluations help ensure that every equipment intended to provide protection does not inadvertently place a worker at risk because of an underlying health condition. This is not merely a requirement I recommend and perform for others. As a physician who uses respiratory protection in healthcare settings, I am also required to undergo periodic respirator medical evaluation to ensure that respirator use remains safe and appropriate for me. I understand firsthand that this process is straightforward, efficient, and focused on safety. I do not view it as a burden. I view it as a routine safeguard that it helps ensure the respirator will protect me without creating unintended health risks. If medical evaluation is important for physicians, nurses, respiratory therapists, and other healthcare professionals, it is equally important for every worker who relies on respiratory protection to perform their job safely. Respirators are essential tools in healthcare, emergency response, manufacturing, public safety, construction, and many industrial settings. They save lives by protecting workers from infectious diseases, dust, fumes, and toxic airborne contaminants. However, respiratory use is not physiologically neutral. Even relatively lightweight N95 respirators increase breathing resistance and require greater effort to move air in and out of the lungs. Respirator use can increase work of breathing, increase perceived exertion, contribute to heat stress, and worsen symptoms of anxiety and claustrophobia in susceptible individuals. For healthy individuals, these effects are generally modest and well tolerated, but not every worker is healthy. For individuals with asthma, COPD, pulmonary fibrosis, pulmonary hypertension, heart failure, obesity, or significant anxiety disorders, the additional physiologic burden associated with respiratory use can become clinically meaningful. As physicians, we should never assume that every patient responds to physiologic stress in the same way. Workers should not be treated differently. One of the strongest arguments for maintaining medical evaluations is the health profile of the modern workforce. The reality is that today's workforce is not uniformly healthy. Nearly half of American adults have cardiovascular disease or hypertension. Approximately 25 million Americans live with asthma. Millions more have chronic lung disease, including COPD, many of whom are active members of the workforce. These conditions are often invisible. A worker may appear completely healthy while carrying out significant underlying cardiopulmonary disease. Supervisors and safety officers are not expected to diagnose medical conditions, nor should they. Employers cannot reliably identify these risks through observation alone, nor should they. Without formal medical review process, employers may unknowingly place workers in situations that increase the risk of respiratory distress, cardiovascular symptoms, panic reactions, heat-related illness, or inability to safely perform essential job functions. Medical evaluations exist precisely to identify these risks before harm occurs. OSHA did not establish this requirement arbitrarily. Medical evaluation is a core component of the respiratory protection standard because respirators place demands on multiple body systems. The OSHA Medical Screening Questionnaire evaluates respiratory disease, cardiovascular disease, neurologic conditions, psychological conditions, and other factors that may affect a worker's ability to safely wear a respirator. The questionnaire screens for conditions including asthma, chronic bronchitis, emphysema, heart disease, high blood pressure, seizure disorders, diabetes, chest pain, claustrophobia, and anxiety disorders. This extensive screening exists because these conditions can affect respirator tolerance and respirator safety. More importantly, the purpose of the evaluation is not regulatory compliance. The purpose is individualized assessment and prevention. Some argue that because most workers are medically cleared, the evaluation process is unnecessary. I would argue the opposite. The fact that most workers are cleared demonstrates the system is efficient. The value of the process lies in identifying the workers who require something more than a one-size-fits-all approach. In occupational health programs, the majority of workers complete the questionnaire and are cleared without restriction. However, studies and occupational health experience consistently show that approximately 5 to 15% of workers require additional review beyond the initial questionnaire, depending on workforce age, job demands, and underlying health status. Those individual evaluations often identify workers who require further medical assessment, temporary or permanent restrictions, alternative respiratory types, workplace accommodations, or ongoing follow-up and monitoring. Many are ultimately cleared, some are not. Others require a different respirator than initially planned. Those are exactly the workers that this process is designed to identify. Even if only 1 out of 20 workers requires additional evaluation, that worker may be someone with severe asthma, significant heart disease, or another condition that could place them at increased risk. Eliminating the evaluation process would disproportionately affect the employees who are most medically vulnerable. Furthermore, not all respirators are the same, and not all workers are the same. A medical evaluation allows a physician or other licensed healthcare professional to consider existing medical conditions, physical demands of the job, duration of respirator use, environmental heat burden, workplace conditions, type of respirator required, whether an alternative respirator may be safer. This individualized assessment by qualified, licensed medical professionals is important because the safest respirator for one worker may not be the safest one for another. As clinicians, individualized assessment is what we do every day. We would never prescribe the same medication at the same dose to every patient regardless of age, diagnosis, or medical history. Respirator selection should follow the same common sense principle. Some have suggested that workers who cannot tolerate an N95 respirator can simply use a PAPR instead. In practice, the situation is often more complex. PAPRs can reduce breathing resistance because they provide powered airflow. For many workers, this is a significant benefit. However, PAPRs also introduce other considerations. They add weight, they may alter visibility and communication, they can reduce mobility and create ergonomic challenges, they may be difficult for workers with neck or back problems or balance disorders, musculoskeletal limitations, or certain cardiovascular conditions. For some workers, a PAPR is clearly a better choice. For others, it may create a whole set of different challenges. A medical evaluation helps determine which respirator protection strategy is the safest for the individual worker rather than relying on assumptions. In healthcare, emergency response, public safety, manufacturing, and industrial environments, respirators are often worn during prolonged shifts and periods of significant physical exertion. The stakes are high. A worker who experiences respiratory distress, cardiovascular symptoms, anxiety-related incapacitation, or other medical complication while performing hazardous work risk injury not only to themselves, but also to coworkers, patients, and the public. Medical evaluations function as a preventative safety measure. They help identify workers who may benefit from further evaluation, accommodations, alternative respirators, work restrictions, or ongoing monitoring before a serious event occurs. That is exactly how good occupational safety programs should function. From a policy perspective, it is important to consider what is actually being proposed. The current process is already streamlined and risk-based. Most workers complete a questionnaire that takes only a few minutes. Only those with concerning responses are referred for additional review. The burden is minimal. The potential consequences of missing significant cardiopulmonary disease are not. Those consequences may include preventable medical emergencies, workplace injuries, lost work time, workers' compensation claims, increased healthcare costs, risk to coworkers and the public. In the healthcare settings, a worker who becomes medically compromised while using respiratory protection may also jeopardize patient care. The modest effort required for medical screening is far outweighed by the potential benefits of preventing foreseeable harm. In summary, respirators save lives, but respiratory protection programs should protect the whole worker, not simply satisfy the equipment requirement. Medical evaluations are practical, evidence-based safeguard that identifies workers who may be at increased risk because of underlying medical conditions. They support individualized assessment, appropriate respirator selection, accommodation when necessary, and prevention of foreseeable harm. As a pulmonary and critical care physician, and as someone who personally undergoes periodic respirator medical evaluation, I view this requirement not as a regulatory obstacle, but as a common sense worker safety measure. Most workers will be cleared quickly and without restriction. But for the minority whose medical conditions place them at higher risk, the brief evaluation may be the only opportunity to prevent predictable and potentially serious harm. The goal should not be simply to place a respirator on every worker. The goal should be to ensure that every worker can safely use the respirator required for their job. If nearly 1/2 of American adults have cardiovascular disease or hypertension and millions more have asthma or chronic lung disease, removing medical evaluation means removing the only systematic process designed to identify workers who may be harmed by the very respiratory equipment intended to protect them. For those reasons, I urge you to maintain the medical evaluation requirement completed by a qualified, licensed healthcare provider as an essential component of every respiratory protection program. Thank you for the opportunity to testify.
Thank you, Dr. McAvoy. Are there questions from the OSHA room, please?
Yes, Your Honor. The first question comes from Dr. Minda Nieblas.
Thank you, Dr. McAvoy, for your testimony. I was wondering if you could state from your experience, particularly with your expertise, have you ever restricted or declined use of a filtering facepiece respirator or PAPR based on information obtained from the questionnaire?
I have not yet, no.
Okay, thank you. We've also heard from other people who've testified that there are questions on the current respirator questionnaire. Are there any that are most beneficial in helping you make your determinations or that address your concerns?
Well, the questionnaires are really a screening tool. It's a very sensitive screening tool to identify people who may potentially have a problem, where the questions that I may answer as being experienced in the areas, I will be then, therefore, you need to tailor to the patient to understand what they say. Oh, I have asthma, I cough. Well, how often do you cough? I mean, it's the questions that I can ask to determine what kind of difficulties they have, or health problems that they may have occur that could affect their use of a particular respirator.
All right, thank you. Thank you very much. One more question. Have you, in your experience, found that issues were discovered or brought to your attention, or people were referred to you after fit testing? Any people who have challenges during the fit testing process?
Yes, I have. And many of them. Yes, I have. I've had
You don't need to
several.
disclose personal information.
Yeah, no, I have. And I always, to be honest, there's some people who, if I get them through the right treatment and such, I can get them to be able to use that respirator, but they wouldn't be able to use it unless I had them get the right treatment. There are certain conditions that are triggered by it. So yeah, I can. So the value of me seeing them and getting them to be able to use a respirator safely is really key. That's what I do mostly.
Thank you. No further questions, Your Honor.
Your Honor, the last question from OSHA comes from me, Andrew Levinson. Dr. McAvoy, I'm trying to explore your statement that it's only a minority of workers that need follow-up and need actual contact with a physician, and I'm trying to figure out the most efficient and effective way to get those workers identified. One of the things that we heard in earlier testimony yesterday and today was that some people thought that the questions were actually not particularly sensitive, and that you could do away with many of them, and that if we simply asked workers to self-identify who wants to talk to a healthcare provider for follow-up, either following training or following fit testing, that might be a way to identify some significant portion of those folks who need follow-up. Do you have any thoughts on whether or not that would be effective or not in addressing the people where you are actually seeing them for more direct medical follow-up?
Well, one, I would say that they misunderstand what sensitivity means when we talk about that. Sensitivity is really broad, and it is very sensitive. That's the one thing that's been established with that questionnaire. Sensitive means that you're going to probably have false positives, people that might have a problem with it, but you don't want to miss anyone because it's a screening program. That's how they work, and they're not specific. So they may say that maybe the questions aren't specific enough. That may be what they were meaning to, but they are really quite sensitive. And when we talk about a minority of people involved, a minority, yeah, but we've got millions of workers, so it's a lot of people potentially at harm. So I do think that the screening, that's why we screen. We screen to identify, make sure we don't miss anyone, and then have them evaluated before you would go to a fit test. Having a fit test before really may miss it, because I've done these fit tests. It's just like you sing, you talk while you're doing it. That's going to miss problems that someone may have to do with heavy exertion with their work type. It really depends on what they do. So yeah. So are all the questions perfect? No, I can't say that that's the case, but the sensitivity of it and the flow and the process, I think, has been a very good process for workers.
Thank you. Your Honor, no further questions from OSHA?
Mr. Barrett, questions from the solicitor?
Joseph Barrett from the Office of Solicitor. No questions from me.
Thank you. Do we have questions from the public?
No questions from the public, Your Honor.
All right. Dr. McAvoy, thanks very much for being here and for your testimony. We very
Thank
much
you.
appreciate it.
Oh,
Thanks.
I appreciate the opportunity.
Okay. All right. Who are we going to have next, please?
Dr. Markowitz, are you ready?
Oh, I am ready. Can you hear me?
Yes.
Yes, we can. Thanks very much for being
Okay.
here. You can start when you like.
Sure. Okay. Good afternoon or good morning if you're in the West Coast. Thank you for the opportunity to speak today. My name is Stephen Markowitz, and I'm an occupational medicine physician. I direct the Barry Commoner Center at the City University of New York. I've also been given some time to present comments later after I present my own comments on behalf of Bob Harrison, who couldn't be here today, and I will delineate those specifically. We approach the beginning of September, which is always a difficult time in occupational health in New York City, especially this year, the 25th anniversary of September 11th. We think of the 126,000 people who are still alive and enrolled in the NIOSH World Trade Center health program because they have cancer, they have PTSD, they have chronic lung disease, or other WTC health conditions. September 11th was obviously, hopefully, a singular event, so you may wonder why it is that I mention it here at a hearing on OSHA medical evaluations for requirements for respirator use. So I was reminded of it when I read the rule, actually, the proposed rule. Let me quote what reminded me of this. Quote, OSHA concludes that the data available for health effects are lacking and insufficient to establish that medical evaluations meaningfully reduce material impairment caused by wearing an FFR or a loose-fitting PAPR. End of quote. In other words, data are not available for health effects associated with respirator use, or that medical evaluations make a difference in altering impairment associated with respirator use. So this issue of how we act in the absence of good evidence is actually central to occupational health. And the principle that we should have used at September 11th, but we didn't, it's quite simple. When uncertain, protect. We didn't know September 11th how and whether the dust and smoke were toxic at ground zero, and we did not make every needed effort to minimize human exposure at ground zero and surrounding neighborhoods. We did not have evidence in hand that World Trade Center exposures could cause anything worse than throat irritation. Some of you may recall we called it WTC cough for a time. So we presumed, as the EPA head said, that the, quote, air was safe, end of quote. So workers were allowed to put in long hours with variable respirator use, leading to undue exposures and subsequent disease. So in fact, we did not have good evidence in either direction soon after September 11th, either that there was a heightened risk or that the conditions permitted safe work. So we employed a default position that permitted exposure in the absence of known risk. We didn't know, so we permitted exposure. And in retrospect, this was a very costly decision. The default position should have been to protect people, as in when uncertain, protect. When we don't know, let's err on the side of protecting people. We face this challenge in occupational health all the time. It's not just in respirator clearance and consideration of what we should do about that. The fact is, for most occupational exposures, we really don't know much about their toxicity. Now, EPA in their chemical inventory has 86,000 chemicals, of which 42,000 are in active use in American commerce. Let's compare that to what OSHA has regulated in 50 years. OSHA has promulgated 29 standards on specific agents and another close to 500 in the Z table, which is outdated. Compare that to the 42,000 that are in active use. Or consider cancer. The International Agency for Research on Cancer has evaluated roughly 1,000 agents for cancer out of the 42,000 in current use. So the fact is, we conclude we don't know a lot in occupational health, and most workplace agents have not been properly evaluated and not properly regulated either. We routinely don't have good evidence. Lack of evidence is actually the rule, not the exception. So we need to employ the precautionary principle, I think, in respirator clearance, just as we should elsewhere, which is when uncertain, protect. I want to respond now to a different issue that was been raised in the hearing, and I think was alluded to in the previous question to the presenter. Some people believe that in the absence of a respirator-associated health evaluation, that relevant worker health concerns can be addressed during a fit testing process or during respirator training, and thereby obviating the need for a routine health evaluation. Personally, I think this makes no sense to rely on a random process where workers are expected to volunteer their health concerns in fit testing or training, which are non-private settings, to people, fit testers or trainers, who may or may not have health expertise to understand those concerns. And furthermore, that there wouldn't be any systematic way to follow up. To try to uncover health concerns in this fashion would violate workers' rights to confidentiality and autonomy. To do it this way would also send the message, frankly, that potentially relevant health concerns are not important enough to deserve specific evaluation. Screening for relevant health issues in respirator evaluation has to be intentional, it has to be systematic, and it has to be respectful. So now I'm going to move to Robert Harrison's comments. Bob is a clinical professor at the University of California, San Francisco Medical School, also in the state health department, worked longtime occupational medicine physician. And he has a number of points, some of which overlap with Dr. McElvoy, so I will try to expedite this. Although, in fairness, he was given 10 minutes, so maybe I actually will use up those 10 minutes. We'll see. In any event, point number one, a medical evaluation determines whether a particular worker can safely perform their work while wearing a respirator. The current OSHA standard explicitly recognizes three elements relevant to respirator use: the respirator itself, the anticipated working conditions, and the employee's medical status. Current evidence that healthy subjects generally tolerate N95s does not establish that every worker, regardless of their health status, can safely tolerate an N95 under actual conditions of use in the workplace. Indeed, the ability to wear an N95 or another FFR or PAPR should not be considered in isolation. And I think Dr. McElvoy actually nicely touched on this. OSHA has said that workplace factors are relevant to determine whether an employee can tolerate respirator use. So it's a consideration not just of the respirator, but the respirator plus the worker's health status, plus the tasks they are being asked to do, plus the overall work environment that must be considered in respirator evaluation. Point number two, a medical evaluation actually is a low-cost screen for vulnerable workers. The current standard does not require that every N95 user undergo costly medical testing. And the initial evaluation can consist of an OSHA standardized confidential questionnaire reviewed by a physician or other professional. This questionnaire can identify, and it's quite detailed in response to a question to Dr. McElvoy, in terms of looking at symptoms and the like, identify workers who have cardiopulmonary problems, respiratory symptoms, claustrophobia, or other relevant conditions. I would also here comment, this comes from me, not Dr. Harrison, that in response to a question in the last session, is that many workers are underdiagnosed with chronic lung disease, particularly blue-collar workers. They have COPD, but it has not been diagnosed by a physician. And so they will not readily come forward and say they have COPD. They may have shortness of breath, they may have exercise intolerance, and they will have undiagnosed COPD. And unless you probe with questions that are contained in the current questionnaire, it's unlikely to be detected. Point number three by Dr. Harrison. The OSHA original evidentiary conclusion pointed actually in the opposite direction of the proposed rule. When OSHA adopted the current standard in 1998, it concluded that adverse health effects could occur even with respirators with low breathing resistance and short-term use, particularly with workers who have cardiopulmonary impairment. OSHA previously explained that respirator use can alter breathing patterns and increase physiologic workload. OSHA therefore concluded that respirator use warranted prior medical evaluation. So given this reasoning, and now 30 years of established policy, the onus is on OSHA to demonstrate that there is now persuasive evidence that warrants a proposed rule change eliminating health evaluations for selected respirator use. Point number 4, lack of evidence of harm is not necessarily evidence of no risk. The OSHA June 2025 memorandum says that the proposed exemption is based on, quote, lack of data indicating adverse health effects, end of quote, in relation to FFRs and PAPRs. 2 comments about that. Adverse events among susceptible workers may be difficult to detect through studies that are primarily designed to assess average physiologic response in healthy populations. And secondly, the current application of the existing medical clearance requirement itself may reduce adverse outcomes in higher risk workers. And therefore, it would be difficult to detect in real world studies because, in fact, those workers have been screened and accommodations have been made. Point number 5, medical evaluation creates an important pathway to accommodation. Under the existing rule, a medical evaluation does not lead to a binary decision, cleared or not cleared. The clinician can recommend limitation, additional evaluation, an alternative respirator. Removing the medical evaluation eliminates a systematic mechanism for identifying these workers before required respirator use begins, not after, at a time in which workers develop symptoms. 2 more points. One, number 6, is actually the burden of the existing requirement is relatively limited. OSHA does not require, to our knowledge, an annual medical clearance. Rather, medical clearance evaluation occurs initially, and then reevaluation is triggered by a change in health or a change in work requirements. And I don't have data on this, but it's likely that this periodic evaluation actually only occurs in a minority of workers. And then finally, point number 7, that healthcare actually presents an especially important case for retaining the medical evaluation requirement. In healthcare, required N95 use occurs in a variety of different settings and tasks. When a person enters an isolation room, when a healthcare worker is asked to wear a respirator on a prolonged basis during outbreaks, during emergencies, during procedures, or any changes that involve substantial physical activity or use of other PPE. This heterogeneity of uses and exposures is not addressed by a regulation that is based on the proposition that the average N95 user imposes little physiologic burden. A standardized medical evaluation gives occupational health programs a mechanism to identify a comparatively small population for whom such heterogeneity of tasks really matter. And I think Dr. McElvoy nicely addressed this point. So in summary, eliminating a low burden confidential screening process will leave a subset of medically susceptible workers unidentified before they are required to wear a negative pressure respirator under potentially strenuous workplace conditions. Thank you for the opportunity to appear today.
Thank you, Dr. Markowitz. Questions from OSHA?
Yes, Your Honor. The first questions come from Dr. Minda Nieblas.
Good afternoon, Dr. Markowitz. Thank you for your testimony. One of the questions I have is one that's you've probably heard before, and I was asking, from your experience, have you restricted or declined use of an FFR or a PAPR based on the questionnaire?
Not based on the questionnaire. Referred people for further evaluation, but not strictly based on the questionnaire.
Could you state, sorry, this is Dr. Nieblas again. Sure. Could you continue or clarify whether or not individuals were diagnosed and ultimately could not wear a respirator or had to have restrictions?
No, for the most part, they could end up wearing a respirator and did not require restrictions. I don't have I mostly do research. I don't have a vast experience in this setting. I don't operate, for instance, an occupational health clinic or the like. But my experience is that they are permitted to wear a respirator, and some number of accommodations are required.
Thank you. Thank you for that. One more question. Are there, in your experience or in your discussions with colleagues, questions on the questionnaire that are most beneficial in helping make your determination on medical clearance?
Sure. I think that the questionnaire is reasonably comprehensive, actually, and touches on most of the important aspects. For instance, what I referred to before, in question number 4, I'm looking at the questionnaire at the moment, where it asks about pulmonary symptoms, where there are a dozen different symptoms which are asked. This is I think, quite comprehensive. And I do think there are a lot of workers in certain sectors, manufacturing, construction, possibly others, who do have undiagnosed chronic lung disease. And I think COPD, chronic obstructive pulmonary disease, is the most common. And then, so if you ask them, do they have COPD, they're going to say no. But then you probe and ask them about specific symptoms, and then you get concerned that they might, and that they need proper evaluation. So I find what appears to be repetitive questions actually quite useful in probing for undiagnosed disease that requires a closer look.
Thank you. I don't have any further questions.
Your Honor, there are no further questions from OSHA.
Thank you. Are there questions from the solicitor?
Joseph Barrett from the Office of the Solicitor. No questions from us. Thank you, Dr. Markowitz.
Are there questions from the public?
There are questions from the public. Kayla Flowers, I have enabled your mic.
Thank you. Kayla Flowers with the United Steelworkers. Hi, Dr. Markowitz. I just have a quick question. You spoke to something that has come up in prior testimony and in also in questions from OSHA. So regarding the identification of health issues that may affect respirator use during the fit testing process, what is the purpose of the fit testing process under OSHA's respiratory protection standard?
Sure. The purpose is kind of self-explanatory, which is that there is an adequate fit to the respirator that's going to be used. I think, if relating to what I said before, that whether health concerns would come up in this setting, I think, is completely ad hoc. And when a person undergoes fit testing, it's for a very short period of use of the respirator. It doesn't really reflect. It helps you in terms of achieving the proper fit, but it doesn't reflect actual conditions of use. But the idea that in that process, the fit tester would somehow be able to detect health concerns that should trigger further evaluation. It could happen, but I wouldn't rely on it, not systematically.
Okay, thank you.
Other questions from the public?
Yes, one other question. Rebecca Reindell, I have enabled your mic.
Wonderful. Thank you. Thank you, Dr. Markowitz, for your testimony. I had a question I was interested in asking you, but I'm wondering it may have been covered a little bit here, both from the previous questioner and some of your responses. But let me ask it anyway for clarification, and if there's anything else you want to add. You were talking about the usefulness as a medical professional in probing workers for information related to their conditions. And then would asking workers during a fit test a general question if they have medical concerns, or if they want to speak to a medical professional about respirator use, serve the same purpose as those probing or prompting that you do get out of the questionnaire, even if workers are sort of checking the boxes and going through the questionnaire?
Yeah, well, so let me admit to a conflict of interest. I'm a physician, so I believe that health professionals actually have an important role here. But seriously, I wouldn't expect, frankly, your average worker who goes for fit testing to admit to health issues to a fit tester. They wouldn't regard that as the proper place to discuss those health issues, and not just on basis of privacy, but sort of what's the point? Because the fit tester isn't the qualified health professional who's going to help you figure out what's going on and what impact it has on your use. So I just think if you're interested in the health status as it impacts respirator use, the only way to approach that is through an evaluation by a licensed health professional, physician, or the like, and not rely on industrial hygienist, fit tester, trainer, or the like. It doesn't make any sense.
Thank you.
Other questions from the public?
No further questions from the public, Your Honor.
Dr. Markowitz, thank you very much for your testimony and presenting that of Dr. Harrison as well. We really appreciate it. All right, who do we have next, please?
Next, we have Scott Robertson. There we go. So I have just promoted you to panelist. You'll be able to unmute and turn your camera on. Hey, Scott. If you are speaking, you are still muted and your camera is still off.
Okay, I'm there.
Perfect.
All right, Mr. Robertson, are you able to hear us?
Yes, sir, I am.
All right, go ahead, please.
All right. Good afternoon, Judge and members of the panel. My name is Scott Robertson. I'm speaking and testifying today in my capacity as an AFGE union representative on behalf of the MVAC and not the Department of Veterans Affairs. I am an AFGE safety steward, and I represent pipe fitters, skilled trades, and employees across a wide range of occupations here at the Department of Veterans Affairs. Thank you for the opportunity to testify today on OSHA's proposal to amending the medical evaluation requirements in the respiratory protection standard for certain types of respirators. The American Federation of Government Employees, AFGE, is the nation's largest federal employee union, representing more than 820,000 federal and DC government workers. AFGE members work across the federal government and include healthcare workers, correctional officers, industrial hygienists, environmental professionals, emergency responders, skilled trades, and many others who rely on respiratory protection to safely perform their jobs. I personally use a powered air purifying respirator, or PAPR, as part of my pipe fitter work. So when I talk about respiratory protection and medical evaluations, I'm not talking about something hypothetical. I'm speaking as a worker who actually relies on this equipment to help protect me while doing my job. Our work can be physically demanding. When I put on a respiratory protection, I need to know two things: that it will protect me from the hazard and that I am medically able to safely use it while doing my job. A respirator is supposed to protect the worker, not create another risk for the worker. And this issue reaches far beyond doctors and nurses. Morgue and autopsy personnel may rely on N95s and PAPRs during procedures that can generate infectious aerosols. Housekeeping employees may enter contaminated environments. Skilled trade employees may encounter asbestos, chemicals, dust, biological hazards, and other airborne contaminants. If we require these employees to wear respiratory protection to keep them safe, we should make sure they can safely use that protection. OSHA's mission is to assure America's workers have safe and healthful working conditions free from unlawful retaliation. VA's mission is to fulfill President Lincoln's promise to care for those who have served in our nation's military and for their families, caregivers, and survivors. These two missions come together inside every VA medical center. We cannot fulfill our promise to care for our veterans if we fail to protect the workers who make that care possible. Under OSHA's current respiratory protection standard, 29 CFR 1910.134, paragraph E, employees must receive a medical evaluation before they are fit tested or required to use a respirator. That protection is also consistent with the broader federal commitment to worker safety established by 29 USC 668, Executive Order 12196, and 29 CFR Part 1960, which require federal agencies to maintain effective occupational safety and health programs. Within VA, VHA safety and occupational health policies further reinforce that responsibility. These protections should work together and not be weakened by removing a preventative safeguard for OSHA's respiratory protection standard. This is not unnecessary paperwork. This is preventative worker protection. And that raises a very important question. If OSHA removes the medical evaluation requirement for N95s and other filtering face piece respirators, FFRs, what systematic safeguard will identify an employee who may not be medically able to safely use that respirator before that employee is placed at risk? Waiting until a worker becomes short of breath, dizzy, overheated, experiences chest pain, or develops another medical problem while performing hazardous work is not prevention. That is intervention after the problem has already occurred. NVAC is also concerned that eliminating mandatory medical evaluations could shift responsibility away from the employer and occupational health professionals and place that burden on the individual employee. Employees are not physicians. A worker may not or may have no reason to know that a medical condition could make the use of a particular respirator unsafe. They may not recognize the warning signs until they are already performing strenuous work, working in the heat, wearing additional PPE, caring for an infectious patient, or responding to an emergency. Think about what that means in an actual VA workplace. A VA employee caring for an infectious patient, entering an area with a respiratory hazard, performing an autopsy, or responding to an emergency should never be placed in the position to having to choose between removing the respiratory protection required to protect them from the hazard or continue working while experiencing medical symptoms. That is exactly the situation prevention is supposed to prevent. The purpose of the medical evaluation is to identify foreseeable problems before the employee is placed in the situation, not after. Some of the healthcare professionals caring for our veterans themselves have served in our military or continue to serve in the Reserve or National Guard. When our service members took their oath, they promised to support and defend the Constitution of the United States against all enemies, foreign and domestic. Today, some of the same men and women continue serving our country in another way by being at a bedside, caring for their fellow veterans. We have a responsibility to protect them while they do it. Because if we fail to protect our nurses, caregivers, housekeeping employees, skilled trades, morgue and autopsy personnel, and other VA workers, we jeopardize their ability to continue serving our veterans. And that veteran isn't just a patient on a chart. That veteran is someone's fellow service member, husband or wife, father or mother, brother or sister. Ultimately, that veteran is someone's loved one. Medical evaluations are part of that protection. They help identify workers who may be at increased medical risk from respirator use. OSHA's own standard recognizes this under 29 CFR 1910.134, paragraph E, 6, Roman numeral 2. When a medical condition may place an employee at increased risk while using a negative pressure respirator, the employer must provide a PAPR if the medical evaluation finds that employee can safely use one. But if we eliminate the medical evaluation, how do we identify the worker who needs that additional protection before something happens? AFGE's position is simple. If you're telling us we need a respirator to do our job safely, then make sure we can safely wear it. Protect the skilled trades who keep our facility operating. Protect the housekeeping employees who keep them clean and safe. Protect the morgue and autopsy staff performing difficult and potentially hazardous work. And protect the nurses and healthcare professionals caring for our nation's veterans. Because protecting the workers protects the caregiver, and protecting the caregiver protects our veterans. Thank you.
Mr. Robertson, thank you, and thank you for your work on behalf of veterans. Questions from the OSHA room?
Yes, Your Honor. The first question comes from Minda Niebles.
Thank you, Mr. Robertson. This is Minda Niebles. Based on your experiences or what you've heard from the membership, do you know of a situation where a medical evaluation was not provided and there was an adverse health outcome from use of a respirator?
Not that I'm aware, but we can address those questions in our post-hearing comments.
Understand. Thank you. This is Dr. Nieves again. Do you know, have you had anybody or your members who may have been cleared at some point to wear a respirator, medically cleared, and are wearing a respirator on the job like you yourself said you did, but wind up having to return for a re-medical evaluation?
No, I mean, the agency does all of that stuff, so that would have to be, contacted through the agency to get that information.
All right. Oh, thank you so much. I appreciate your testimony very much. This is no further questions from Minda Niebles.
Your Honor, the next questions from OSHA come from Bob Blicksilver.
Hi, Bob Blicksilver, OSHA Standards and Guidance. Does AFGE or the Department of Veteran Affairs have any survey data, or have there been any studies within your membership or DVA on current practices with regard to respirator usage, medical clearance practices and procedures, and training on respirator usage? Are you aware of any survey data, sir?
Mr. Blicksilver, we can address that in our post comments if you would like.
Excellent, thank you. And if you want to add any personal observations as well, that would be welcome. Those would be welcome. Bob Blicksilver again. Are you aware of any data on the number or percentage of workers at AFGE work sites who receive a medical evaluation from a physician? Or alternatively, are you aware of any data on the number or percentage of workers at AFGE work sites who indicated on the screening survey that they have a condition warranting a medical evaluation?
I'll defer that to our post-hearing comments as well, so we can collect all that data for you.
Okay. Any data that you, Bob Blicksilver again, any data that you have on the prevalence of medical evaluation among members whose use of respirators may elevate the risk to employee health? If you have any data on prevalence of that type, that would also be useful to us.
Okay.
Thank you. That's all I have. Thank you. Thank you, Judge.
Your Honor, no further questions from OSHA.
Questions from the solicitor?
This is Tessa Zavislin from the Solicitor's Office. I have no questions. Thank you for your testimony, Mr. Robertson.
Thank you.
Do we have questions from the public?
No questions from the public, Judge Bell.
All right. Mr. Robertson, thanks very much for your testimony. We very much appreciate it.
Thank you very much. Have a good day.
Thank you. Who do we have next, please?
Next, we have Dr. Bruce Lippy. And I've just promoted Dr. Lippy to panelist now. taking a moment.
Dr. Lippy, if by chance you're speaking, we're not able to hear you.
There we go. Okay. So you should be able to unmute and turn your webcam on when you're ready.
Yep.
Welcome, Dr. Lippy. Go ahead, please.
Thank you. I greatly appreciate this opportunity, not just to speak, but to be with such a distinguished panel. Again, my name is Bruce Lippy. I am a certified industrial hygienist and a certified safety professional, and I have my own consulting firm. I began my career as an industrial hygienist working at Maryland OSHA back in 1978. And really, I've worked as a practitioner most of the time. During my career, I've worn air purifying half-face, full-face respirators for hundreds of hours in asbestos removal projects. And for 2 months during the cleanup of the World Trade Center destruction as a member of the IUE's hazmat unit. And Steve, I am one of the 126,000 in the program, the WTC program, and it is an excellent service. So I was very appreciative of that. I've also worn a full-face, tight-fitting PAPR on the cleanup of the anthrax attack in the AMI building in Boca Raton, Florida. I'd like to emphasize that a powered air purifying respirator switches from positive pressure to negative pressure when the battery dies, and that was a regular issue working long hours in the hot AMI building. So I was able to attend the entire hearing yesterday, and I found it quite valuable, but I would like to amplify 3 key points that I heard yesterday. One is the hierarchy of controls was raised several times. And I consider it personally an absolutely critical concept for proper management of worker protection. And again, it was repeated a number of times yesterday, but respiratory protection is at the absolute bottom of this hierarchy. And OSHA has made that abundantly clear that employers need to show that engineering and administrative controls aren't practicable before turning to respirators. And I think that's an important point. I do not want to denigrate respirators. I have trusted my health to NIOSH certified respirators throughout my entire career. But as pointed out yesterday, they are the last line of defense. And so I find the idea of decreasing protections that are currently in place very misguided and potentially harmful to workers. My second point is this. There was considerable discussion yesterday about the mandatory questionnaire, with some indicating it was antiquated and could be replaced by having the same questions asked during fit testing or training. I agree with Steve Markowitz that this is really misguided. I've done lots of quantitative fit testing and rarely asked medical questions because I am not qualified to do so. And so I needed to focus on what I was there for, and that's properly conducting a quantitative fit test to make sure no one was entering a contaminated work area with a poorly fitting respirator. That was my job. And I think that would be the way most folks doing fit testing would feel. I have spent a lot of time with peer trainers in the NIEHS worker training program, and I have always admired their credibility with workers, which I have never had as an IH geek. They trust peer workers. But these people don't have the medical or scientific background to handle the application of questionnaires to a class of 15 or 20 or more workers. First off, the logistics would be overwhelming. I have taught OSHA Institute courses with peer trainers, and really the paperwork is quite time-consuming. Not to mention now asking these trainers to handle confidentiality issues, possible violations of HIPAA, and most important, a lack of a licensed medical profession to ask questions to when unsure. I would routinely get calls from trainers with industrial hygiene questions, and I was happy to help them. I agree that the questionnaire could use some updating. According to the OSHA docket, the questionnaire was adapted from an ANSI Z88.6 standard from 1984. That's 42 years ago. I like Dr. McClellan's idea yesterday of bringing together stakeholders and respirator experts to redesign the questionnaire. But it's important to keep in mind that the questionnaire currently is quite comprehensive, and it was a compromise to avoid incurring medical professional costs if the questionnaire didn't show any untoward health issues. So I am against getting rid of it. I work in construction where a majority of firms have less than 20 employees. And so a contact the worker has with a licensed healthcare professional may be the only time he or she has that before working. My third point is this. I have no interest in trying to rebut the argument that most healthy individuals will suffer no harm from wearing a filtering face piece respirator without a previous medical evaluation. I think that's generally correct, but that totally misses the point that 1910-134 wasn't written to cover only healthy workers, which unfortunately is what predominates in the literature. Medical evaluation, as you've heard quite often, I'm sure, is intended to identify workers with conditions that could predispose them to adverse reactions, particularly when respirators are worn for long periods. Again, this is rare in the literature, but it's very common in many workplaces. We heard about hospital settings, and I can tell you from construction, if the weather's good, you keep working. Finally, I've worked with OSHA on projects like creating the disaster site worker courses and VPP inspections, and I found their efforts at Ground Zero to be exemplary. But building this proposed elimination of medical evaluations on, quote, a lack of data about medical evaluation efficacy really speaks to the need for further NIOSH research funding, not cuts. It's important to note, unfortunately, that this administration, rather than better funding NIOSH, nearly eliminated it until the uproar from health professionals and others forced the reinstatement of most of the staff. I've relied on NIOSH all my career. I'm glad to see it back. Consequently, I strongly urge OSHA to not go forward with these proposed changes, and I thank you for your time.
Dr. Lippy, thank you very much for your testimony. Questions from OSHA, please?
Yes, Your Honor. First questions from OSHA come from Dr. Minda-Nieblas.
Hello, Dr. Lippy. This
Hi.
is Dr. Minda-Nieblas. Based on your experience, does the need for further medical evaluation to determine if there should be limitations on respirator use, does that become most apparent, or is that more likely to become apparent when the worker is answering the medical questionnaire, when the worker is being fit tested, or after using the respirator for a while in the workplace?
Well, I would say the questionnaire, because people just complain about respirator wearing. It's not like it's a specific health issue other than it's uncomfortable. When I taught the folks at the business school in Maryland, where I am, I make someone wear a respirator for the whole class and ask them if they thought about the cost of that versus the uncomfortable nature. And usually they were very concerned about how much the pain of wearing a respirator. So I would say the medical questionnaire is where you're going to probably get at that the best.
Thank you. No further questions.
Your Honor, next questions from OSHA come from Dr. Bob Blicksilver.
Hi, Bob Blicksilver, OSHA Standards and Guidance. Dr. Lippy, do you have any experience advising clients on the choice of filtered face piece respirators and powered or purifying respirators in relation to medical evaluation? And if so, what do you find to be the typical time length for modifying respirator usage and achieving satisfactory fit, or any other measures of accommodation when you are consulting, providing consultation and instructions on remedying exposure and any elevation of a medical condition? What measures of accommodation and any unit cost measures that you can identify in relation to accommodating the relocation or reassignment of workers?
Yeah, one of the numbers that jumps out at me immediately is the difference between a filtering face piece respirator and a PAPR. The latter, a lot of times, runs $1,000, and then you have to buy cartridges. So it's much easier to put people in filtering face piece respirators. I have worn PAPRs, and they can provide more comfort, as far as the temperature, the air is blowing across your face. But they are expensive, and I've not found a lot of employers that want to shell out that kind of money.
Right. Thank you. Bob Silver again. If you have any thoughts on the time involved in examining the worker, considering the conditions, and advising the actual time of a consultant such as yourself or any other physician or a licensed healthcare professional or anyone who would be brought in, that would be helpful to us. If a range of time estimates depending on the conditions that you've observed in your career. Any thoughts that you might have on, assigning the expenses, administrative and resources expenses involved in accommodating workers for certain medical conditions?
Well, I don't know about the specific conditions, but I'll tell you, if I'm called in to advise on respiratory protection, I want to see the work area. I want to know if they're wearing other PPE, because it's been stated, but you really need to look at the entire package. So, it's usually at least a half a day for me to get out and look at what they're doing and look at the production. And I've worked a half a mile underground where they're storing nuclear waste for the Department of Energy. It's a very different operation than healthcare. So you really need to look at where they're doing the work, how many workers are involved, how many are going to be wearing respirators, because not all of them have to. I'm working out west at a nuclear weapon cleanup in Hanford, and there's just a limited number of workers who are in self-contained breathing apparatus. The rest are in full face air purifying. The costs are dramatically different. So it really takes a focus on what's going on. And also, are there engineering controls that can alleviate even wearing respirators? And they're doing that on this project in Hanford. They're putting in stacks to take care of the exhaust.
Okay.
That help?
Yeah, thank you very much for those observations. If you have any further thoughts and post-hearing comments, we would really welcome
happy to do it.
Getting those from you. Thank you. Again,
Sure.
Bob Silver. Thank you very much, Dr. Lippy.
Yes.
All right. And Your Honor, the last question comes from Dr. Jonathan Bear.
Jonathan Bear, OSHA.
Yeah.
I was wondering, Dr. Lippy, based on your experience within the construction industry, do you workers face any hazards or perform work tasks while wearing an FFR loose-fitting PAPR that would prevent them from being able to take their respirator safely off for a few moments? This is either for, removal because of a medical reason or removal for comfort or to readjust fit. Are there things they're being exposed to that would present adverse health outcomes rather immediately?
There's a situation in construction that's quite different than other work environments, whereas we call it bystander exposure. So there are situations where you may be doing okay, but there's dust or vapors coming from somebody else's operation. So it's tricky to say that it's okay at any one point to take it off, other when you're going into a break room or having lunch. So I really caution folks to be careful about everything that's going on around them before they take off a respirator. The other thing with construction is a lot of the places they work, it becomes tough to get into the spaces they do. I'm thinking of pipe fitters and plumbers while wearing particularly a PAPR. It's a cumbersome piece of equipment that can get caught in all kinds of things. So that can jerk it off your face while you're working. And some of the exposures in construction are quite significant. So I would be very hesitant about saying if you're a little hesitant, just pull the respirator off. The only time I would say that I would reverse that is when we taught about heat stress and inside containment for asbestos work. I taught workers that if somebody goes down, looks like they have heat stroke, cut the damn plastic and get them out of there, because the risks from the asbestos is not nearly what it's going to be for somebody who may be suffering from heat stroke. I don't know if that helps. I'm just giving you some examples.
Thank you. That's the only question I have.
Your Honor, no further questions from OSHA.
Thank you. Questions from the solicitor?
No questions. Sorry, this is Joseph Barron from the Office of the Solicitor. No questions from us. Thank you, Dr. Lippy.
Do we have Do we have questions from the public?
Yes, we do. First person, Rebecca Rindell, I have enabled your mic.
Wonderful. Thank you. Thank you, Dr. Lippy. This is Rebecca Rindell with the AFL-CIO. I think I have two questions for you. The first is that it sounds like your professional opinion is that medical evaluations must be done prior to fit testing, but please correct me if I've misstated that. And then, so as part of that, OSHA requirements aside, current OSHA requirements aside, would you feel comfortable fit testing someone on a respirator that they haven't been medically cleared for already?
No, I think the medical clearance should come first. And really, questionnaire facilitates that. You don't have to have a doctor involved right up front.
Right. Okay. Yep. Thank you. And then my second question is confidentiality aside, like removing that from this picture during fit testing, which is your experience, do you think that during fit testing, workers would answer a general question about volunteering to talk to a medical professional if they're given no other medical information because it's not a medical professional asking it? In other words, the confidential information would follow up that converse after with a medical professional would follow if they were referred. Do you think workers would still volunteer for that after they've been fit tested or
No, my experience has been that workers can be quite reticent about discussing medical issues unless it's somebody they truly trust. And you know, quite often you can end up getting into trouble by talking about your medical condition if the boss finds out.
Okay, thank you very much.
Yes,
Oh,
my pleasure.
Other questions from the public?
Yes, there are 4 others in the queue right now. MK Fletcher, I have enabled your mic.
Hi, thank you so much. I'm MK Fletcher with North America's Building Trades Unions. My question was actually very similar to Rebecca Randell's second question. But Dr. Lippy, I was just wondering if you could kind of further expand on what you said. You particularly about how workers feel the ability to speak up or not speak up. Even if just the question during a fit test or a training was would you like to speak with a medical professional? You mentioned just earlier that they could feel that they might have experienced trouble if they do speak up, and I was just wondering if you could expand on that.
Well, again, I work in construction, and most firms are small, so everybody knows each other. There is turnover, but you know, they tend to be very reticent about speaking. And there's also this. It's almost a male profession, unfortunately, MK, and the bravado is part of that. At the World Trade Center, we couldn't get people to admit they were having mental issues or any kind of health problems, and so we had this 10,000-mile stare coming out of workers. So you know, I think that's really a problem, particularly again in a male-dominated profession. It's just not saying anything. And what would you know to say if you haven't even checked for some of the issues? A lot of folks have health issues and they just live with them.
Thank you so much.
Sure.
Next question from the public, please.
Dan Glucksman, I have enabled your mic.
Hi, Dan
Hey, Dan.
Glucksman.
Yeah,
Good
how are you, Dan?
Good. Two questions. One, earlier in your comments, I think, and maybe it was some in discussion with one of the OSHA panelists, there was a question about why would an employer choose a filtering face piece respirator versus a powered air purifying respirator. And one thing I didn't hear was assigned protection factor, and that sometimes the exposure is such that a worker needs that higher level protection. but that's like one of the key factors, right? In terms of
Oh, no,
choosing.
absolutely, Dan. You're right. It is. And
Um,
a powered air purifying respirator, of course, gives you a much higher protection factor than a filtering face piece.
right. Maybe just a note that I haven't heard that much discussion on APFs in some of the testimony. I guess maybe I thought I would have heard some discussion of that, but one other question: how often in your experience are insurers kind of directing um the type of personal protective equipment, or I guess in this case, respirators, whether it's a FFR, half face mask, say with a N95 or P100 particulate filter.
Yeah, Dan, I don't think I've had much experience at all with the insurers being a driving force for choice of respirators.
Okay.
That's not been my experience.
Okay, great. Thank you.
Oh, sure.
Next question from the public, please.
Ellie Barbarash, I've enabled your mic.
Thank you so much. This is Ellie Barbarash. I'm from
Hello.
APSME. Dr. Libby, it's a pleasure to hear your testimony and to meet you. I'm another 9/11 first responder, so thank you for your service.
Sure.
I have two quick questions. One of them thinking about the APF. My first question was, the last thing you had shared in your testimony was about someone getting heat stress in asbestos containment. So what I'd like to highlight, and perhaps you can expand upon what I'm going to suggest, is that the deregulation proposal suggests that because we're not in an IDLH situation, if we're overwhelmed wearing an FFR, we can just take it off for a minute and then leave the work site, as if that won't really kill us. So there's taking it off for comfort, but then if somebody is overwhelmed by heat stress, we know that if the temperature goes beyond a certain threshold, I think you're dead in 4 minutes. So time is of the essence. So taking it off in that situation is a matter of life and death, right? Yet
Sure.
asbestos is also a carcinogen that you don't want to be cumulatively adding to breathing in or whatever else you're in, especially in a hazardous waste site. I was just wondering if you could address those differences in the proposal, that it's not a big deal to take your respirator off in a hazardous situation versus the exposure to you when you do versus when you have no choice because you're going to be dead in 4 minutes, so you better get it off of you.
It's prioritizing risk, and heat stroke again is just an absolutely major event that you have to take care of, or they will. In the case that I dealt with in Mosh, two folks died at Bethlehem Steel from heat stroke, and they weren't handled well. So that's number one. After that, it really becomes a question of where are you working. If you're outside, and I know a lot of filtering face piece respiratory protection folks do get outside and can take them off, as opposed to being in a medical clinic. But generally, we really frown on taking respirators off until you're completely done with the work and out of the area. In fact, in asbestos, we routinely fired people who took off their respirator inside containment. So it's serious business.
Dr. Lippery, at 9/11, I was helping out at the decontamination chambers at John and William Streets, and I was helping utility workers with their decontamination. And my instructions to them, as I was instructed, was to tell them to take their respirator off only in the shower after they had completely ungarbed, so that they would have water capture for any contaminant there. The other thing I just wanted to ask about was about protection factors. So an FFR is a protection factor of 10, or at least an
Right.
N95 or something.
Yes.
Loose fitting PAPR, I think of 25, right?
I believe that's correct.
But what about when I'm in containment and my battery goes? Do I have any protection factor at that point?
I've never worked with a loose fitting PAPR. They scare me a bit. So I've always tight face seal. And in that case, you refer to and we always fit test that in the negative mode to make sure you've got a good fit. So I really can't comment on loose fitting PAPRs, although they're very common in the medical profession.
Yeah, I would say that I don't know that there is a protection faction there because they're not negative pressure and they're not tight fitting. And without a battery, there is no filtration. That's all my questions are. Thank you so much.
Sure. Thank you.
Do we have other questions from the public?
No further questions from the public, Your Honor.
All right. Dr. Lippy, thank you very much for your
My pleasure.
testimony. We greatly appreciate it.
You're welcome.
Who do we have up next, please?
Next, we have Kelly Taylor, who I've just promoted to panelist. So you should be able to unmute and turn your camera on when you're ready.
Ms. Taylor, I hope you're not talking because we're not able to hear.
Can you hear me now?
Yes, I can. Thank you very much. Go ahead,
Great.
please.
Can you see me?
Not yet.
Okay, let me see if I can fix that. My camera does not want to participate.
Well, we can hear you fine. So if you're okay to go without video, go ahead, please.
I sure am. Sorry about that. So thank you for the opportunity to participate in this public hearing. My name is Kelly Taylor. My career began 35 years ago as a physical therapist caring for people recovering from injuries and illnesses, including work-related injuries. I then worked for the Minnesota Department of Labor and Industry, first in the Workers' Compensation Division as a policy analyst, and later at Minnesota OSHA as a program analyst, where I developed and implemented policy and reviewed investigator case files before citation issuance. In my more than 10 years at Minnesota OSHA, I read thousands of case files filled with documentation of workplace hazards that put lives at risk. My coworkers at Minnesota OSHA and the employees working in OSHA state plans and federal offices across the country work every day to save the lives of America's workers. Currently, I work in a leadership role at DeMarco Solutions. DeMarco partners with 3M to provide RespExam, an online respirator medical evaluation system developed and physician reviewed by board-certified occupational medicine physicians. DeMarco has provided RespExam respirator medical evaluations for more than 20 years and has processed more than 2 million evaluations. That gives me, through my role at DeMarco, a practical view of how the current medical evaluation requirement works for employers and employees. It also gave me access to data that, with its limitations, is real-world, real worker data. I'm testifying today because I cared about injured workers as a physical therapist. I cared about injured workers as a workers' compensation policy analyst. I cared about preventing workplace injuries and illnesses as a Minnesota OSHA employee, and I continue to care about the American worker. In 1998, OSHA promulgated the Comprehensive Respiratory Protection Standard that established the current medical evaluation requirement. In the preamble to that final rule, OSHA stated that the purpose of the medical evaluation requirement is to ensure that an employee who is required to use a respirator can tolerate the physiological burden of respirator use. OSHA identified multiple conditions that may compromise an employee's ability to tolerate respirator use, including, but not limited to, cardiovascular disease, respiratory disease, and reduced pulmonary function. OSHA stated that these conditions may place workers at increased risk of illness, injury, or death. OSHA described the medical evaluation requirements as minimal requirements necessary to protect respirator users. OSHA also rejected an approach that would have exempted employees using respirators for fewer than 5 hours per week because a short use threshold could miss workers with pre-existing medical problems and leave workers at risk. That is the foundation of the current rule. So the question is, what has changed? How respirators work and the physiological burden they create have not changed. FFRs are still tight-fitting, require a face seal, and rely on the wearer's own respiratory effort to draw air through the filter. Workers still vary in their cardiovascular and respiratory health, their physical capacity, and their ability to tolerate respirator use. Required respirator use still occurs under actual working conditions, including heat, exertion, protective clothing, and prolonged duration. The physiological burden OSHA identified in 1998 remains relevant today. Studies conducted since the 1998 rulemaking and cited in my original comment continue to support OSHA's original concern that respirator use, including N95 or comparable FFR use, can affect breathing, cardiovascular demand, and exercise tolerance. Some of those studies specifically noted that the effects may be more significant for people with pulmonary disease, cardiovascular disease, or other medical conditions. OSHA's own proposal cites recent studies of healthy volunteers to argue FFRs have minimal physiological impact. That caveat is important because OSHA's medical evaluation requirement is designed for the actual workforce, not for healthy volunteers in controlled studies. A review of 2 recent years of RespExam data shows that among referred FFR users with follow-up received, 15.4% were restricted and 11.6% were determined unable to wear an FFR. Of note, roughly 2/3 of both groups had been referred for pulmonary or cardiac symptoms. Those are not theoretical workers. Those are workers who were screened because their employers were complying with OSHA's current standards. Those are workers whose medical evaluation identified a need for restriction or disqualification before they were required to wear an FFR, indeed, before they were fit tested. I want to be candid about this data's limitations. It comes from RespExam customers, not a nationwide sample. While employers are encouraged to provide follow-up documentation for every referred employee so we can update the employee record, in most cases, they do not. I do know from my experience assisting employers that some use the screening as the final determination as to whether the employee is given tasks that require respirator use. So there are many referred employees whose final outcome is not entered into the RespExam system. Additionally, RespExam was designed to assist the employer in complying with the medical evaluation requirement efficiently and cost-effectively. To that end, most workers are evaluated for several respirator types at once, and isolating evaluations for FFR and PAPR use only is difficult and necessarily narrows the set. With those limitations, the RespExam data still aligns with OSHA's own data. In its proposed amendment, OSHA points to low refusal and limitation rates after medical evaluation, asserting figures around 1 to 2%, and appears to treat those low rates as evidence that the screening process has limited impact. Applying that 1 to 2% to OSHA's estimate of 2.6 million private sector non-mining FFR users represents 26,000 to 52,000 workers who, if OSHA statistics are correct, are medically unable to wear an FFR or require restrictions or limitations to do so safely. And it has been asserted in previous testimony, as well as OSHA's proposal, that the total number of FFR users is likely understated. A low denial or limitation rate does not mean medical screening lacks value. It means most workers are cleared efficiently, while the screening process identifies the workers who need follow-up, restriction, limitation, or disqualification to protect their health. That is how screening is supposed to work. OSHA's proposal is internally inconsistent. The proposal would remove the medical evaluation requirement for FFRs and keep it for tight-fitting PAPRs. But FFRs are also tight-fitting respirators that require a face seal, and unlike a PAPR, which uses a blower to deliver air to the wearer, an FFR requires the wearer's own respiratory effort to draw every breath through the filter. I'm not raising this because OSHA should also exempt tight-fitting PAPRs. It should not. I raise it because the inconsistency shows OSHA has not adequately analyzed the health basis for removing medical evaluations for required FFR use. This exemption is broader than the way it has been described, including in OSHA's presentation to its Construction Advisory Committee, which framed the proposal around N95 dust masks. The proposal is not limited to N95s. It applies to required FFR use across all 9 NIOSH particulate filter classes, including P100s, which have higher filter efficiency and higher flow resistance than N95s. It is also worth noting that after considering OSHA's presentation, the Construction Advisory Committee recommended that OSHA not proceed with this proposal. OSHA has proposed this amendment as a cost-saving measure. By OSHA's own accounting, roughly 2/3 of the projected savings is a single line, the $193.75 cost of each follow-up medical exam. OSHA assumes 23% of screened workers are referred for follow-up exams, while acknowledging in its own proposal that the rate may be much smaller for these respirators. The RESP exam referral rate for FFR and PAPR only evaluations for the data I reviewed was 3.5%. Cost savings should not be treated as net benefits without considering what the medical evaluation requirement does. Eliminating medical evaluations does not eliminate medical risk. If workers who would have been restricted or determined unable to wear an FFR are instead required to use one, financial costs may be shifted to employers, insurers, and the workers' compensation system. But the most important cost is not financial. It is the risk imposed on the worker who may be required to wear a respirator that a medical evaluation would have shown they could not safely tolerate. The current requirement is being met through questionnaire-based screening at modest cost, and America's workers are worth it. Listening to previous testimony, I noticed that the panel returning repeatedly to the same request for data and studies. It is apparent that the data OSHA seeks to properly analyze this proposal is not readily available. It will take time, money, and perhaps administrative burden in the form of mandatory reporting by employers to obtain comprehensive data to fully analyze this proposal, the very things deregulation attempts to avoid. In the meantime, the lives and livelihoods of America's workers hang in the balance. OSHA should not finalize the proposed amendment. I also want to speak to a question Dr. Niebles has asked several previous hearing participants, whether retaining paragraph E7, reevaluation when symptoms arise, would address the concerns raised. Paragraph E7 should be retained, but it is not a substitute for the initial medical evaluation. Under E7 alone, a sometimes nondescript symptom arises, and we hope the worker recognizes it, understands it, and reports it. Appendix C currently instructs the employee in OSHA's own mandatory language that to maintain your confidentiality, your employer or supervisor must not look at or review your answers. Under E7 alone, the only path to a medical evaluation is by disclosing symptoms to the employer or supervisor, and OSHA trusts that the employer will act on the employee's report. Additionally, if the adverse reaction arrives as an event rather than a symptom, the employer bears the cost, the recordable injury, the workers' compensation claim, the lost time. Thank you for the opportunity to testify.
Thank you. Questions from OSHA?
Yes, Your Honor. The first question comes from Jonathan Bear.
Jonathan Bear, OSHA. Thank you, Ms. Taylor, for your testimony. I was wondering, in your post-hearing comments, to the extent that you can you provide the data to which you were discussing in your testimony?
So yes, I've already provided the data that I found relevant. And I just want to acknowledge that I really do want to be helpful to OSHA. I want to help provide data. We have pledged to our customers that the information that they provide will not be sold or shared with anyone. So I can't provide any raw data. The system was designed to help employers comply with the current requirement and to manage that information securely. It was not designed to mine data. So what can be, compiled has real limits. I can certainly provide the same statistics that I've provided. I do believe they are already in my comment.
Thank you. A couple more questions. The data to which you have, or through personal experience, are you aware of how often workers discover they have a condition solely through the questionnaire?
I'm really glad you asked that question. I was hoping you would, because I've heard you ask several others. I don't have data. I do have anecdotal experience. As we run this online respirator medical evaluation system day in and day out for literally hundreds of thousands of employees, those that are referred often contact us after their referral. And some of them are strongly believe they should not be referred. I don't think I should be referred. And so in that situation, what we do is we go through their evaluation, the answers they provided, to make sure that they didn't accidentally provide the wrong answer. And in many cases, they have provided yes answers to symptoms that, should be concerning. And yet they don't think they should be referred. And in those cases, we're like, you know, when they're confirming the answers they provided were correct, and we inform them that, no, you really do need to go see a doctor. In addition to that, many of those employees express reticence at the fact that, do they have to tell their employer why they were referred? And once we tell them that, no, they don't, they do not have to tell their employer why they're referred, they feel much better about that referral, and they're willing to go see that doctor.
Do you know by chance how frequently that occurs?
So we don't track that, and I would say it's less than once a week, but more than once a month.
Thank you. And my other question is, does the data that you have, or your personal experiences, how often do workers who are cleared for using an FFR or a loose-fitting PAPR, do they have an incident while working and request a reevaluation?
We don't have that data. Our system is limited to the scope of providing a service for the employer to easily and cost effectively meet the requirement. So we don't have contact with employees in that respect.
Okay, thank you. Those are all my questions.
Your Honor, the next question comes from Bob Blicksilver.
Hi, Bob Blicksilver, OSHA Standards and Guidance. Ms. Taylor, you described scenarios where if a worker who would have been restricted or determined unable to wear an FFR after medical evaluation, if they're instead required to use one, costs may be shifted downstream through workers' compensation claims, lost time, restricted duty, replacement labor, and higher experience rated premiums. I'm quoting from your written testimony. Do you have any empirical data? Have you yourself or DeMarco or are you aware of any other studies with empirical data on those or related costs of removing medical screenings from FFR and PAPR fit testing? And also, could you share your thoughts and post-hearing comments in relation to that area of shifted costs from the failure really to reduce the likelihood of the enhancement of these medical conditions? Thank you.
Yeah, I do not have empirical data. I would be happy to share my thoughts in post-hearing comment.
Bob Blicksilver.
Thank you very much, Ms. Taylor. That's all I have.
Your Honor, we actually have one final late-breaking question from Dr. Minda Nieblas.
Thank you, Dr. Minda Nieblas. Thank you, Ms. Taylor. I was wondering if from your data, you're able to determine which questions from the questionnaire are most commonly associated with the request for referrals and inability to clear the employee.
I haven't thought of that. It's certainly something I can try to think about and go back and look at and provide in post-hearing comment.
Thank you so much. I appreciate it.
Mm-hmm.
Your Honor, no further questions from OSHA.
Questions from the solicitor?
Joseph Barrett from the Office of the Solicitor. No questions from us. Thank you, Ms. Taylor.
Do we have questions from the public?
There are no questions from the public, Your Honor.
All right, Ms. Taylor, thank you so much for being here. We really appreciate it.
Thank you.
Do we have any other witnesses to appear before us?
No.
All right. We're now at the end of all scheduled witnesses for today. Following the hearing, there will be 2 separate periods for submitting additional information. Hearing participants may submit additional evidence or data relevant to the proceedings within 30 days of the end of the hearing. Participants then will have 45 days after the end of the hearing to file briefs based on the record as a whole. The purpose of having these 2 periods is to allow for the submission of new data and evidence and to include additional responses to questions posed at the hearing, and then to have a period that allows participants to respond to that new evidence. Therefore, new data, studies, or similar evidence may not be added during the second period, and commenters should reference the docket ID number for any evidence they rely on in their briefs. Today is August 20th, 2026, so the deadline for submitting additional evidence or data is September 19th, 2026, and the deadline for submitting briefs will be October 4th, 2026. At that point, the record for this hearing will close. The public hearing on the proposed rule amending the medical evaluation requirements in the respiratory protection standard for certain types of respirators is concluded. Let the record show that all persons and organizations who filed a timely notice of intention to appear have been extended an opportunity to do so. Let the record also show that in every instance, following the presentation of oral comments and testimony, an opportunity has been extended for questioning of the witnesses by those who had filed notices of intention to appear, and by members of OSHA's panel. On behalf of the Department of Labor, I wish to publicly thank all those persons who gave of their effort and time and testimony and expertise to contribute to this hearing today. To all participants, thank you for your interest and your important contributions to this matter. The hearing is hereby adjourned. Let's go off the record, please.
And Katie, if it's possible, can we go back into a practice session with just the OSHA, DOL, and the judge and ERG folks?
I am unable to do that, but if you'd like, I can set up another webinar or another meeting space really quick.
No, I think we can contact Judge Bell separately through a Teams chat is probably the easiest.
Yes, I'll be available.
All right. We'll give you a call in a moment, Your Honor.
Thank you all.
Thank you. Take care.
Thank you.